And they set it up to make it hard as hell.
Yeah, it's Ariana Johnson.
Okay.
It ain't loading, Tiffany.
Yes.
Hi.
I just seen.
I don't see your dad. Damn, I'm trying to cook.
What if somebody's I'm gonna meet somebody. I'm looking. Let me see.
We're hearing feedback, so if somebody has their mic on, please turn it off.
Hey Judge, that was coming from y'all's end. I had to mute y'all. So, I mean, if they have that computer to the side turned on, that may be the issue. We can't hear you now, so they'll have to turn that computer, they gotta turn that one over off and then.
All right, you good now?
All right. Good afternoon. This is your first appearance hearing. A first appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charges that have been filed against you. Second, I will ask you if you have an attorney representing you. If you have hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing it until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know that you will have court. No one else will do that for you. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask if you can afford one. If so, we will make note of that and move on. If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you, pending you filling out an application. You have a right to have your attorney present before and during any questioning. You also have a right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Third, if there are any challenges to probable cause, I will address those. Finally, I will review your bonds and/or other release conditions with you to determine if any changes are necessary. Be aware, if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go in effect immediately, meaning even while you remain in custody. So if you are given a no contact order, it is in effect immediately. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where you all are located, is being recorded. There is an assistant state attorney present listening to everything that is being said. So do not say anything about the crime itself. Please keep these rights in mind as we go through the process. For those of you appearing virtually, if you are a non-lawyer, you are to keep your devices on mute during the entire time you are present. In addition, you are not to turn your video feed on at any time. For the lawyers present, please keep your devices muted. However, please do turn on your video so the court is aware you are present. For all of those present, pursuant to the rules of judicial administration, this meeting is not to be recorded in any form unless you are the press and you have prior permission from court administration. South and Central, can you swear the defendants in, please?
All rise and raise your
All
right
right,
hand.
everybody stand up for me, please. Everybody stand up.
Raise the right hand.
Hey, yo. Yo, man. Stand up. Everybody stand
Swear to
up.
tell the truth, the whole truth, say I do.
I do.
May be seated.
Control chaos.
All right, I do see that we have a few defendants that need interpreters, so I will start with those first. They appear to all be at Central. I'm going to start, it looks like, with Yves Pervers.
That's the Creole.
I'm sorry, say that again?
Creole.
Okay, Creole, okay. Mr. Moise, is that correct?
That is, Your Honor, I only have one, Jean Desir. Monsieur Yves, est-ce que vous parlez créole?
Oui.
Yes.
Okay. All right. I need to swear you in, Mr. Moise.
Yes.
Can you raise your right hand for me? Do you solemnly swear or affirm that you will translate from Creole to English and from English to Creole and from Creole to English accurately to the best of your ability?
I do. For the records, Alex Moise, certified court interpreter.
All right. I'm going to read the oath that I need you to also swear in Ms. Pervers on also. If you could relay this to her. And I don't know, go ahead.
m'a fait reconnaître que il pourra lire, ça que nous pourrons lire là, c'est pour tendre tout le monde qui parle créole.
Oui.
Yes. Your Honor, may the interpreter start?
Yes.
OK. Bonjour tout le monde qui parle créole. Nous, là, je dis, pour la première fois que nous parlons devant le juge, nous parlons pour la première fois, il y a 4 raisons pour ça. Première raison, m'a fait nous connaître qui accusation contre nous-mêmes. Deuxième raison, m'a va demander nous si nous avons un avocat qui représente nous. Et si que nous prenons propre avocat ou et avocat présent, avocat a parlé pour nous. Si avocat n'est pas présent, c'est nous-mêmes, nous avons une opportunité soit pour nous pas pour continuer avec cas sans avocat, ou bien si que nous voulons que l'avocat présent demain, nous capable de demander pour renvoyer cas pour demain. Maintenant, si que renvoyer cas demain, c'est responsabilité nous-mêmes seulement pour nous faire avocat connaître que nous gagnons pour nous tourner dans le tribunal demain. Personne n'a pas fait ça pour nous. Maintenant, pour l'autre bagarre encore, si que nous pas capables de prendre un avocat, le juge là a permettre que nous libérons un avocat de la défense publique. Ça le pourra faire, il pourra poser des questions pour voir si que nous qualifions pour cela. Si nous qualifions pour cela, la banne application et ensuite la remplir l'application. Maintenant, nous avons tout droit pour nous gagner avocat nous présent le que il a posé nos questions ou bien le que nous là dans le tribunal. Alors, nous avons tout droit pour nous communiquer avec avocat nous, avec famille nous ou avec amis nous. Et si nécessaire, il y a nous possibilité par téléphone ou autre pour nous capable de communiquer avec nous. Troisième raison, si que n'a pas le checker connaît, c'est qu'il y a une cause probable. Bon, j'ai raison pour arrêter nous. Et finalement, m'a prévisé bon ou caution que vous mettez sous nous. Et si que moi que vous besoin pour justement soit monter bon ou bien baisser bon, m'a fait si nécessaire. M'a fait nous connaître que dans le tribunal là, dans avant procès, que ce soit si que nous gagnons pour nous retourner sous condition de bon ou autre, nous avons fait tout effort, nous avons fait tout effort immédiatement pour nous capables de faire nous tourner. Ça veut dire que si que nous capables de nous, si que nous payer l'argent, nous capables de faire nous sortir, ou bien si nous capables de nous, si nous pas capables de payer l'argent. Si que nous avons l'ordre pour nous gagner aucun contact avec le monde qui est victime, nos contacts, ça, ils commencent immédiatement. Et durant toute procédure là, il faut que nous comprenions que nous n'avons pas aucun contact avec le monde d'une façon ou d'une autre. Ensuite, indiquez-nous pour nous pas dire rien qu'on y a là de cas. Parce que tout ça que nous dit, il y a un avocat de la défense, un avocat de l'État, assistant qui l'a capté tout ça n'a dit. Donc, m'a dit nous, pas dit rien. Donc, droit ça, moi, mettez devant nous et qu'embé dans l'esprit nous. Pour monde qui apparaît sur virtuellement, et qu'embé système là éteint et par visuel, c'est-à-dire qu'embé écran éteint et aussi qu'embé microphone éteint. À moins que vous soyez avocat, c'est seul ça seulement capable de mettre l'humain vidéo, mais il faut que le microphone reste éteint.
All right, Mr. Perverge, you are charged with an expired driver's license by more than 6 months. Do you have-
Monsieur,
Go ahead.
excusez-vous que vous avez 6 mois depuis que licence expirée.
Do you have an attorney?
Est-ce que vous avez un avocat? Monsieur, vous entendez samedi, est-ce que vous avez un avocat?
I don't think we can hear them.
Central, you're muted.
Monsieur,
Central County
est-ce que vous
Jail,
avez un
you're
avocat?
muted.
Monsieur, ma reprendre encore, est-ce que vous avez un avocat?
Non, mon honneur, m'a pas gagné.
No, I do not have an attorney.
Would you like one?
Est-ce que tu as voulu que le juge là-bas un avocat?
Oui, mon honneur.
Yes, yes, Your Honor.
Having reviewed the probable cause affidavit, I do find probable cause. You can relay that.
L'homme révisé affidavit, moi jeune qui a bon genre cause probable pour te kembe ou là.
I'll impose a $500 bond. If you were to bond out on that, you would have pretrial release with a condition of not driving without a valid license. However, I do see that there is a ICE hold, which means you would be held with no bond.
M'a pété un bon et caution sous de $500 et avec une condition ou pas doit conduire pendant que ou pas gon licence. Mais entre-temps, moi ouais que gagner on ça les ice hold, c'est-à-dire ice mandé pour yo kembe ou jusqu'à ce que vienne chercher ou. Donc à cause de cela, m'a retiré bon en sous.
At the bottom, oh, I see. Sir, would you like a public defender?
Monsieur, est-ce que tu as voulu que me ba un avocat de la défense publique?
Oui.
Yes.
I'll provisionally appoint the public defender.
M'a ba un avocat de la défense publique.
Thank you.
Merci, monsieur, il est terminé. Yo fini, monsieur, vous m'êtes allé.
Right here.
We'll go ahead.
No.
All right, looks like we have someone that would normally, I guess, have an American Sign Language interpreter, but I've been told that we're going to have the captioning on so that she can read. Is that correct?
Yes,
That would be-
Judge.
Okay, and that would be Ariana Johnson?
Yes.
Okay, and then she can communicate also?
Wait
Your
a
Honor,
second, Judge. Who is it? That's your name.
Yes.
Your Honor, I'm sorry to interrupt, but I was told by the Department of Interpretation that we are going to have an ASL interpreter tomorrow at 9 o'clock for Miss Ariane Johnson.
Okay, so they have arranged that for her then?
Yes, for tomorrow at 9
Okay.
o'clock.
Okay, we'll go ahead and hold her over then for tomorrow.
Your Honor, this is Alex Murray, the Creole interpreter. I had another case mentioned to me here. That's Jean Desir.
All right. Second.
She's there.
This is the name with the first letter.
Jean is there.
Hold on 1 second. So I think it's Vizier or Desir. Is it Vizier with a B or Desir?
With a D, David.
Desir.
C'est Jean Desir?
Oui.
Yes.
All right, we'll continue with you then, Mr. Moise, so that you can get that finished. Is he your only other one today?
Yes, that's the only last one that I have, Your Honor. Yes.
Okay, and it appears that he is also at Central.
Il pas été dans Central.
Can you go ahead and relay the oath to him also, Mr. Moise?
Absolutely, Your Honor. Bonjour, monsieur. Ça, c'est la première fois parler devant juge. Et première fois que on a parlé devant juge, c'est pour 4 raisons. Première raison, juge n'a pas le faut connaître qui accusation que vous gagnez contre vous-même. Deuxième raison, m'a demandé aussi un avocat qui représente vous. Et si que vous te prenez un avocat, avocat présent, alors avocat cela a parlé pour vous. Mais si que avocat pas présent, vous avez une possibilité pour continuer avec un représentant tout, ou bien pour demander pour avocat présent. Alors, on a envoyé cas pour demain. Et si que nous renvoyons cas demain, c'est vous-même qui avez responsabilité pour parler avec avocat ou pour faire connaître que demain, vous gagnez au tribunal. Ah, c'est pas nous. Personne ne peut faire ça pour vous. Maintenant, si vous n'avez pas un avocat, je vais demander si vous êtes capable de payer pour propre avocat. Si vous n'êtes pas capable de payer pour propre avocat, je suis capable de poser quelques questions et faire remplir une application pour moi si que vous êtes capable d'avoir un avocat de la défense publique. Et si que vous n'avez pas de moyens, il y a un avocat de la défense publique. Vous avez tout droit pour un avocat qui est présent, leur pose aux questions et aussi qui est présent pendant qu'il n'y a pas d'avoir ici. Maintenant, nous avons tout droit aussi pour communiquer avec avocat, pour communiquer avec famille ou amis. Et si c'est nécessaire, il y a pas de possibilité pour capable faire bagaille ça. Troisième raison, c'est la pas demander la pas ouais si il y a une raison probable, cause probable pour te kembe. Et quatrième raison, il pas réviser bon et caution pour ouais si que bon trop haut ou bien s'il trop bas. Moi, faut connaître que si que yo mettez ou yo lagué ou sous bail temporaire, maintenant que ce soit ça qui arrive, que ce soit au Kembe ou bien que ce soit au lagué là, yo mettez mando pour pas communiquer avec mon avec victime ou pas doué communiquer avec victime d'aucune manière ou d'une autre. Et bagay ça, il commence immédiatement qu'on y a là. Durant tout procès, tout droit constitutionnel pour rester en silence, pour pas dire rien. Raison, c'est que il y a un avocat de l'État, un assistant qui attendait exactement tout ça qu'on dit et a enregistré son dit. Et ça dit, il est capable d'utiliser contre vous-même. Donc, ma demande qu'on y a là, je dis là, pour pas dire rien du tout. Maintenant, pour l'autre monde, Your Honor, this is it for the interpreter.
Okay. I don't know that he's been actually sworn in. Can you have him raise his right hand and then I'll read that back to you so that you can read that back to him?
Certainly. Monsieur, levez mes doigts pour forcément.
All right. Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
Est-ce que vous sermentez que tout ça qu'on va dire là, c'est la vérité, toute la vérité, rien d'autre que la vérité?
Oui.
Yes.
Okay. Mr. Desir, you are charged with domestic violence, battery, touch, or strike.
Monsieur Désir, il est accusé de violence domestique, agression et ou t'es frappé au monde.
Do you have an attorney?
Est-ce qu'on a un propre avocat par où?
Non.
Non.
Would you like one?
Est-ce que tu as aimé que le juge là-bas un avocat?
Oui.
Yes.
Okay, I'll provisionally appoint the public defender.
Ma pas un avocat de la défense publique provisoirement.
I have reviewed the probable cause affidavit. I do find probable cause.
Moi réviser affidavit de cause probable là, moi joindre que bon, j'ai raison pour être arrêté au tout bon.
I do see that this was a reclassified offense, and I will impose a $5,000 bond. If you were to bond out, you would have pretrial release with conditions to not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You would be allowed to have contact with the victim, but you're prohibited from being physically or verbally threatening, violent, or abusive in any manner whatsoever.
M'a pété un bon sous de $5,000. Et aussi, m'a pété en interdiction avant procès devant vous, ou pas de aucun contact du tout avec victime, non, contact violence. Et ensuite, m'a joindre que je dois ou pas capable de retourner dans le cas là pour causer aucune violence.
However, there is an ICE hold, and I do find that you're subject to that ICE hold, so you will be held no bond.
Néanmoins, moi joindre que ICE m'a depuis au Kembeo et au sujet pour ICE Kembeo là, n'a Kembeo sans bon, sans caution.
All right, thank you.
Merci,
one
monsieur,
second.
terminé.
Hold on one second.
T'en as-tu moment?
another person that might need the Creole interpreter, but
Okay,
he might be
Okay.
unavailable. This doesn't need to be translated. If I could just inquire from the jail if this person is available or unavailable.
okay, all right, just one second. Mr. Desir, you're good. Sorry.
No, we might
Monsieur
need.
Désir,
Oh.
terminé, on va
No,
aller.
that's not the interpreter.
Oh,
That was the defendant.
Is
Yeah.
there? Okay. Okay.
All right, Mr. Moaz, can you stay one moment? We're checking to see if we need you for one more.
Certainly, Your Honor, no problem.
He remains unavailable, so we do not need him, but thank you. I just wanted to make sure before you left.
Okay. All right, thank you, Mr. Moaz. I think that's all we have today for you.
Thank you, Your Honor. You have a good day.
All right, you too. All right, now it looks like we have a couple at both South and Central for the Spanish interpreter.
Good afternoon, Your Honor. Clarissa Hernandez, certified court interpreter.
All right. If you could go ahead and give the speech, if you have that in front of you.
Yes, I do, Your Honor.
All right, go ahead.
Thank you. Buenas tardes. Esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si usted tiene un abogado que lo represente. Si ya usted ha contratado a un abogado y éste se encuentra presente, entonces será el abogado quien hable en su nombre. Si su abogado no está presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si decide posponerla, será su responsabilidad contactar a su abogado para informarle que deberá presentarse a su audiencia. Nadie más hará esto por usted. Si usted desea continuar sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si tiene los medios económicos para contratar uno y de ser así, tomaremos nota de esto y continuaremos. Si no tiene los medios económicos y califica, el juez asignaría provisionalmente la oficina del defensor público para que le represente, sujeto a que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Asimismo, tiene derecho a comunicarse con su abogado, familiares o amigos y, de ser necesario, se le proveerán los medios apropiados para hacerlo. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, revisaré su fianza y otras condiciones de su puesta en libertad para determinar si es necesaria cualquier modificación. Tenga presente que si el juez lo pone hoy bajo libertad condicional, ya sea de manera directa o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún bajo custodia. Entonces, si se le ordena no tener contacto con determinada persona, esta orden entrará en efecto inmediatamente. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde se encuentran ustedes, está siendo grabado. Hay un abogado de la Fiscalía presente escuchando todo lo que aquí se dice, así que no diga usted nada sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Para quienes comparecen de manera virtual, si no son abogados, debe mantener su dispositivo en silencio durante todo el tiempo que estén presentes. Además, no deben activar su cámara en ningún momento. Para los abogados presentes, mantengan su dispositivo en silencio. Sin embargo, por favor, activen su cámara para que el juez esté al tanto de su presencia. Para todos los presentes, conforme a las reglas de administración judicial, esta audiencia no podrá ser grabada en ninguna forma, a menos que usted pertenezca a los medios y tenga autorización previa de la administración del tribunal. Muchas gracias. Thank you, Your Honor.
Thank you. We're going to start with Manuel Benitez Saladana, who I believe is at South County.
Creo que este señor está en la cárcel del sur, South County, el señor Benítez Saldana Manuel Antonio.
All right. Ms. Hernandez, if you could have him raise his right hand and we'll swear him in.
Your Honor, the interpreter cannot see South County. I don't know.
Okay.
Okay,
Can you just-
but I can tell him to raise his right hand. No
Okay,
problem.
thank you.
Señor Benítez Aldana, por favor, levante su mano derecha.
Sí.
Yes.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Señor, ¿jura o afirma que las evidencias que usted está por dar serán la verdad, toda la verdad y nada más que la verdad?
Sí, su señoría.
Yes, Your Honor.
Mr. Benitez Saldana, you are charged, it looks like a warrantless violation of probation for burglary of a conveyance, occupied conveyance.
El señor Benítez Aldana, usted está imputado, parece ser que es una violación de probatoria sin orden de arresto por un cargo de allanamiento de un medio de transporte ocupado.
All right, and then I had a question. It looks like he also has another open case, 26 CF 6688.
Y bueno, tengo aquí una pregunta. Parece que él tiene también otro caso abierto, el número 26 CF 6688.
That looks like that was a warrant for domestic violence battery, but I believe he's already been on first appearance and he was ordered to pretrial release. You have
Me
that?
parece que ese caso era por una orden de arresto, por un cargo de violencia intrafamiliar, agresión física, pero creo que ya él ha comparecido en la audiencia de primera comparecencia por este cargo y se le ordenó ya que estuviera en libertad condicional.
Okay, and he's already set arraignment on that one? Yes. Okay, all right.
That went to first appearance with a pretrial release order on July 13th, 2026. And this is Scott Matthews on the record for the state.
Él ya fue a una primera comparecencia y ya tenía una orden de libertad condicional el 13 de julio del 2026. Este es el señor Scott Matthews para que conste en el acta por la fiscalía.
I have reviewed the VOP affidavit and I do find probable cause for the violation of probation. You would be held no bond on that.
Ya yo he revisado el affidavit de la violación de probatoria y determino que hay motivo fundado para el cargo de violación de probatoria. Se le retendrá en la cárcel sin fianza por ese cargo.
All right, and let me ask, did you want an attorney?
Déjeme preguntarle, señor, ¿quiere usted un abogado?
Sí.
Yes.
All right, I will provisionally appoint the public defender for you on that.
Entonces yo voy provisionalmente a asignarle un abogado de oficio para ese cargo.
All right, and then based on the fact that you were on pretrial release for the domestic violence aggravated battery, that will be revoked pursuant to Parker.
Y basándome en el hecho que ya usted se encontraba en libertad condicional por el cargo de violencia intrafamiliar con agravantes, agresión física, esto será revocado de acuerdo con la ley de Parker.
So you will be held no bond. Thank you, sir.
Se le retendrá en la cárcel sin fianza. Gracias, señor. Ya terminó.
Okay, it looks like our next one is Alvin Cabezas.
Alvin Cabezas.
All right, Ms. Hernandez, could you please tell him to raise his right hand?
El señor, por favor, levante la mano derecha.
Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
¿Jura o afirma que la evidencia que está por rendir será la verdad, toda la verdad y nada más que la verdad?
Correcto.
Correct.
Can you get him to say yes, please? He needs to say yes.
Señor, usted necesita contestar con sí.
Sí, sí.
Yes, yes.
All right, Mr. Cabezas, I have that you are here on 2 warrants that are out of county. One for burglary of an occupied dwelling while wearing a mask, that's out of Hillsborough County. And then another warrant for grand theft second degree, also out of Hillsborough County.
Y señor Cabezas, usted tiene aquí, yo tengo enfrente de mí 2 órdenes de arresto, una por un cargo de entrar en una vivienda ocupada mientras que llevaba puesta una máscara. Esta orden de arresto fue dictada en el condado de Hillsborough, y también otra orden de arresto por hurto de mayor cuantía, segundo grado, y también fue dictada del condado de Hillsborough.
Do you have an attorney?
Señor, ¿tiene usted abogado?
No.
No.
Would you like one?
¿Quiere tener un abogado, señor?
Sí.
Yes.
Oh, Your Honor, I believe that's a Hillsborough case, so we can't be appointed to that.
You're correct. I'm sorry about that. All right. Mr. Cabezas, because these are out-of-county warrants, I cannot appoint the public defender for you on this.
Señor Cabezas, debido al hecho de que estos son 2 órdenes de arresto dictadas fuera del condado, yo no puedo nombrarle un abogado de oficio a usted para estos casos.
State, I just had one question.
Yes, ma'am.
On the first out-of-county warrant, when I was looking at the paperwork, I didn't see any reference to the warrant for the burglary of an unoccupied dwelling while wearing a mask.
Y tengo una pregunta. En la primera orden de arresto dictada fuera del condado, cuando yo estaba viendo los papeles, no vi ninguna referencia a la orden de arresto por el cargo de allanamiento de una vivienda ocupada mientras que llevaba puesto una máscara.
Your Honor, the information from out of county comes through a teletype system that I do not have access to.
Su señoría, la información que nos llega fuera del condado viene a través de un sistema de teletipo.
So I am unable to provide substantive additional information.
Y ese sistema yo no tengo ningún acceso, por lo tanto no puedo proporcionar ninguna información adicional sustanciosa.
That said, classifications will sometimes provide information to me to forward to the court if given time to do that.
Y a veces, habiendo dicho eso, el Departamento de Clasificaciones a veces nos proporciona información que yo puedo transmitir al juez o a la jueza si se me da tiempo para eso.
That is part of the Polk County Sheriff's Office, which, as I know the court is aware, has independent constitutional authority from my office.
Y eso es parte de la oficina del sheriff del condado de Polk, que, como ya lo sabe la jueza, tiene una autoridad constitucional independiente de mi oficina.
I would be pleased to reach out to them to request information.
Y yo con mucho gusto me comunicaré con ellos para solicitar información.
I would respectfully suggest holding the accused no bond on the count that the court does have paperwork on, and set both counts for a status review next Friday. And I will attempt to get more information from classifications in the meantime, if that pleases the court.
Respetuosamente, yo sugiero retener al acusado sin fianza por el cargo para el cual la jueza sí tiene documentación, y programar ambos cargos para una revisión de estatus para el próximo viernes. Y yo intentaré obtener más información de clasificaciones. Eso sería mientras tanto, si eso está bien con la jueza.
I think she wants the Hillsborough documentation. That's what? Is he held? I apologize for the crosstalk, judges, to facilitate the proceedings if I may.
Yep.
The defense counsel has pointed out that the accused may be held on a Polk matter currently.
Yes, mental health for the Office of the Public Defender. It looks like 15 CF 9293. It's confusing because it's not on docket sheet, but it is on the bookend sheet where it says failed to redeliver, hired, leased, and it is mentioned in the affidavit. There was no bond amount, so you could appoint us and set a bond amount, I believe, on that.
You have to turn the volume on the TV off to get that.
Can you give us the case number one more time?
Of course, ma'am. 15 CF 9293.
I showed on the.
15,
Yes.
So
So it was the doc or?
he had pled on June 30th. So that's most
To
likely what.
the first VOP. Oh, no, because that was
This
County.
is the Polk County.
Okay,
case that
he
we're-
pled on that
He
already?
pled on that one, so that's probably why he's being brought back.
Okay, I get it now. Yes, thank you, Madam Clerk. Looks like he may have resolved that. Once that is resolved, that they're being held on, sometimes they will bring them back and then talk about sending them over to the other county. Thank you for clarifying that.
All right, so then that Polk warrant is already disposed of, it sounds like.
Thank you.
so it was resolved in Polk County on July 20th, according to Stack.
Okay. And you said you had a different date? Not that, I don't
Well,
know.
this is just the date that he pled to.
Okay.
Other-
Okay.
I didn't see the case number.
Yeah. No.
Well, because we closed here,
You mean those
and
friends?
he spoke on it, but then
Right.
not held it.
Some sort of status hearing.
This is the date that I believe he's done.
Okay, all right.
Thank you for that.
All right, Mr. Cabezas, I do find probable cause based on the documents for your out-of-county warrant out of Hillsborough for grand theft in the second degree. I am going to hold you no bond on that. As to the other out-of-county warrant, we don't have the information on that, but the state has asked to bring you back, I believe on August the 14th, at those first appearance hearings to see what the status is on that other charge.
Señor Cabezas, entonces sí encuentro motivo fundado basándome en los documentos para la orden de arresto fuera del condado dictada de Hillsborough para el cargo de hurto de mayor cuantía en segundo grado. Lo voy a retener sin fianza por ese cargo. Por el otro cargo, no tengo una orden de arresto, pero por esa la fiscalía ha solicitado que se le vuelva a traer a usted de vuelta para que comparezca aquí el 14 de agosto en otra audiencia de primera comparecencia para ver el estatus que tiene ese otro cargo.
Thank you.
Gracias.
De nada.
I didn't sign anything else on that. Okay.
All right, our next one, it looks like is Ubaldo Garcia.
Ubaldo García.
Can you tell him to raise his right hand, please?
Por favor, señor, levante la mano derecha.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Jura o afirma. ¿Habla inglés, señor? ¿No necesita
Yes.
interpretación?
No.
Apparently he doesn't need interpretation, Your Honor.
Okay, all right. Mr. Garcia, do you need an attorney?
Yes.
All right, I'll provisionally appoint the public defender. Just give me one moment while I review the probable cause affidavit.
State, do you have a suggested bond on this one?
Your Honor, it's charged as an F2. There's not a standard bond for an F2 in the bond schedule pursuant to administrative order. I think a typical bond is a $15,000 bond. Of course, that is discretionary with the court. I have read the affidavit in this case. I have not reviewed any victim contact. If that has been made, that would be before the court. With it being F2, my suggestion has to be a $15,000 bond.
Counsel?
The victim was just here in jail, and she needed a sign language interpreter. So I'm sure they probably do not have victim contact. I would say a $1,000 bond would be appropriate in the case because this is a pulling of a shirt, and she's also arrested. So this may be even a mutual combat kind of situation in regards to this.
Having reviewed the affidavit, I do find that there's probable cause. This was domestic violence aggravated battery on a pregnant victim, which is a felony in the second degree. And I will impose a $15,000 bond on this one. If you do bond out, there will be pretrial release with conditions. That would be to not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're also prohibited from having any intentional contact with the victim identified in the arrest report, notice to appear, or complaint affidavit directly or indirectly in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons except for scheduled court proceedings. You must also stay 500 feet away from the victim's home, vehicles, place of employment, and/or school at all times. You're also directed to stay 500 feet away from the event location. Thank you, Mr. Garcia. And it looks like we have a couple at Central as well. Be Brian Lorenzo Aguilar.
Brian Lorenzo Aguilar. Your Honor, may I tell him to raise his right hand?
Yes, you may.
Por favor, señor, levante la mano derecha.
Do you
Jura
swear
o
or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I'm sorry, Your Honor. ¿Jura o afirma que la evidencia que está por rendir será la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
It looks like Mr. Lorenzo Aguilar, you are charged with DUI, one count of DUI, .15 or higher.
Parece aquí, señor Lorenzo Aguilar, que usted está acusado de un cargo de manejar bajo los efectos con una lectura de .15 o mayor en el alcoholímetro.
Would you like an attorney?
Señor, ¿quiere tener un abogado?
Sí.
Yes.
I'll provisionally appoint the public defender. And just give me one moment.
Provisionalmente voy a nombrarle un abogado de oficio. Deme un momento, por favor.
It looks like, is this one, I have a nice one. It looks like they do. There, yes, it says that they would be issuing a detainer for him. But you said it's somewhere that they reclassified it? Yes. All right, Mr. Lorenzo Aguilar, I have reviewed the probable cause affidavit. I do find probable cause. I will impose a $5,000 bond. Were you to bond out, you would have the condition of not possessing or consuming alcohol. This would be a condition of pretrial release. And you would also be subject to random urinalysis testing at your own expense. However, I do see that there is an ICE hold for you, so that will be, you will be held no bond.
El señor Lorenzo Aguilar, he revisado el motivo fundado en el affidavit, encuentro que hay motivo fundado. Voy a imponerle o le impondría una fianza de $5,000 y si usted pudiera salir bajo fianza, usted estaría con condiciones de libertad condicional que serían entre ellas no poseer ni consumir alcohol. Esa sería una condición de libertad condicional y usted también estaría sujeto a que se le exija someterse a pruebas aleatorias de orina y usted tendría que pagar por esas pruebas. Sin embargo, yo veo aquí que usted está sujeto a una orden de retención por parte de ICE, por lo tanto se le retendrá en la cárcel sin fianza.
Thank you.
Gracias, señor.
And I think our last one for the Spanish interpreter is Juan Espinosa.
Juan Espinosa.
All right, if you can
Señor,
have him raise his
levante,
right hand.
señor, levante la mano derecha, por favor.
Do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
¿Jura o afirma que la evidencia que está por rendir será la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
Mr. Espinosa, I see that you are here for a felony warrant out of the state of Texas.
Señor Espinosa, veo que usted está aquí compareciendo el día de hoy por una orden de arresto de un delito grave que fue dictada en el estado de Texas.
Because this is an out-of-state warrant, I cannot appoint the public defender to represent you.
Y debido a que esto se debe a una orden de arresto dictada fuera del estado, yo no puedo nombrarle un abogado de oficio que le represente.
And you are going to be held no bond.
Y se le retendrá en la cárcel sin fianza.
All right. Thank you.
Gracias.
South or Central, do we have any others that I'm unaware of that need a Spanish interpreter before I let Ms. Hernandez go?
Not at South.
No, Judge.
All right, Ms. Hernandez, you are free to go. Thank you so much for your help. All
Thank you, Your Honor. Have a nice afternoon.
right, you too.
Would you like us to call our South County? Oh, never mind.
Just one moment. I have a private attorney here, so I'm going to check with him again about who he's representing.
Gibson Nash.
He's still not here yet.
All right, then we'll recall.
Okay. I'm just gonna step outside for a
Is
quick.
he expected today or?
He's in the hospital. He's not coming today.
Oh,
Sorry.
That's what I was wondering.
Yeah,
all right, well, they had him as CCJ, so, but, that's fine. I'll check for the docket tomorrow.
Okay, he'll be reset for the docket tomorrow.
You can check with him, see if he came from the hospital since we got the update, but
You said you think he's at Central? No.
last we heard, he was at the hospital.
Okay. I mean, we can check. That's like the confusion.
Central, do you have Gibson Nash there?
No,
South County?
not here.
Okay, yeah, he's still in hospital.
Thank you.
All right, thank you. Yes, reset it for tomorrow. South County, you can go ahead and start calling, please.
Your Honor, our first one, Caraballo, refused.
Is this the first time for refusing?
That I'm aware if he wasn't on the docket yesterday.
Your Honor, if, we could be appointed to Mr. Carball, he's kind of help with the Office of the Public Defender. Sometimes there are refusals, there are issues that we need to examine and help the court with. If we could be appointed to his case and, go from there.
Okay, I'll provisionally appoint the Public Defender's Office, and we'll reset this to be heard at first appearance tomorrow.
Thank you.
The next one is Dibert Gregory, Deibert.
Hold on, what was that?
DEI.
Which one? Were they supposed to have an interpreter? I have. I've been in the hospital. Dibert, Gregory Wallace Dibert, is that correct?
Yes, ma'am.
Mr. Dibert, you are charged with violation of injunction for protection against domestic violence. Do you have an attorney?
No, ma'am.
All right, would you like one?
No, ma'am.
All right, so you're declining to have the public defender appointed to you? Are you wanting to represent yourself or hire a private attorney?
I suppose I should have a public defender.
Okay, you would like the public defender to be provisionally appointed for you?
Yes, ma'am.
Okay, I'll go ahead and provisionally appoint the public defender for you. I have reviewed the probable cause affidavit, and I do find probable cause. I'm going to impose $2,000 bond requirement. If you do bond out on that, you'll have pretrial release with the condition of having any contact with the victim. And this includes any direct or indirect contact in writing, in person, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and or school at all times. And you're also directed to stay 500 feet away from the event location.
Yes, ma'am.
All right, thank you.
Have a seat over here. Next, Drynan. Drynan Christopher, Drennan.
All right. Mr. Drennan, you're charged with possession of drug paraphernalia, possession of methamphetamine, possession of cannabis resin, failure of a registered owner of a vehicle to notify the DHSMV of a change of address, and driving while license suspended or revoked. Third offense, which is a felony. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay. I'll provisionally appoint the Office of the Public Defender. Just give me a moment while I review the probable cause affidavit. All right, Mr. Drennan, having reviewed the probable cause affidavit, I do find probable cause for the charge of possession of drug paraphernalia, possession of methamphetamine, possession of cannabis resin, failure of a registered owner of a vehicle to notify DHSMV of the change of address, and also the driving while license suspended or revoked third offense. I will impose a $1,000 bond on the possession of drug paraphernalia, $5,000 bond on the possession of methamphetamine, $5,000 bond on possession of cannabis resin, $250 bond on the failure of a registered owner of the vehicle to notify the DHSMV of the change of address, and a $5,000 bond on the driver while license suspended or revoked third offense. If you do bond out on those, I will impose pretrial release. There will be no driving without a valid driver's license. As well as no possession of any illegal drugs. Thank you.
What was that total bond altogether? I'm sorry. Oh,
Next up, Heskew,
Can you spell that last name?
H-A-S-K-E-W.
All right, Mr. Haskew, I see that you've been charged with some out-of-county warrants out of Brevard County. The first one is for fraudulent use of a personal ID of the state of Florida employee, forgery, public record, or certificate, uttering a forged instrument, and falsifying a public or court record. Because these are out-of-county warrants, I cannot provisionally appoint the public defender for you. I am going to review the probable cause affidavit, so just give me a moment, please.
Yes, ma'am. Thank you.
All right, I have reviewed the probable cause affidavit. I do find probable cause, and you will be held on those charges, no bond.
Yes, ma'am.
Thank you.
Thank you.
Next is Jones Justin.
3 of the 4 counts, yes. I'm sorry, can you call that name again?
Last name Jones, first name Justin.
All right, Mr. Jones, I see that you are here on 2 warrants for a violation of probation for using or possessing drug paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay, I'll provisionally appoint the office of the public defender. I do find probable cause based on those warrants, and you will be held no bond. Thank you.
Thank you.
All right, next up is Parker Nigel.
Good morning. Ugly Miss thing.
All right, Mr. Parker, I see that you're here on a warrantless violation of probation out of Broward County for organized communications fraud, conspiracy to commit, as well as 8 counts, warrantless violations of probation for forging an auto title, and then as well as 4 counts, a warrantless violation of probation for using a 2-way communication device to commit a felony. And because these are out-of-county warrants, I will not be able to appoint the office of the public defender. And you will be held no bond on those charges. Thank you.
Excuse me, Your Honor.
Yes.
I've been held for 7 days already on these accounts, and I thought I might be released because I've been brought already for these charges already. 7 days ago.
Your Honor, from what I understand in our office, this is Pam Hoff, the Office of the Public Defender, he had charges here in Polk that were dismissed, and they brought him to court. Generally, what happens is when charges are dismissed, they're brought to court, the other location of the warrant is contacted to see, are they going to come get him? And then it's reviewed. For example, the judge may feel that 7 days is sufficient for them to come and get him, then they consider possibly releasing them. If we could have an update, if they generally don't tell us the day exactly, but has there been contact with the county, and is there a plan to have him transported?
You're asking me if we've heard from them? Is that what you're?
Yeah, usually the jail can give us some information in regards to that. If this case, and let's also make sure that I have the no bill of where he's should be released on the charges here. So first, I would ask the jail if he's released on any charges or being held on any charges here in Polk, and if not, have they contacted the other jurisdiction, and is there a plan to pick him up?
South, do you have any information on that?
We weren't given any information.
Again, that's outside of my office directly. My experience with that is that while there is a division of the Polk County Sheriff's Office that deals with that, it is separate from the individuals who, the bailiffs who are handling the first appearance hearings at the jails themselves. Again, I don't have access to that communication system at all, but I know that sometimes classifications is listening. Considering the charges and the number of the charges, I would just request that he be held another week and not be ROR'd. I think that is discretionary with the court either way. And what I can do, as with the other case, is simply send an email to classifications and ask if they have information. That is a request from me. I can't order them to do anything, but I'd be pleased to do that.
Usually they are responsive classifications whenever there's a question about anything.
Okay.
I found them to be extremely responsive and would answer your question, I'm sure.
Okay, all right. All right, Mr. Parker, I am going to continue to have you held for another week and bring you back if you have not been picked up by that time.
Yes, Your Honor.
All right, thank you.
Next is Roth Michael, ROTH.
Can I get a name one more time?
I think
Thank you.
All right, Mr. Roth, you're here on a charge of resisting without violence, possession of drug paraphernalia, and possession of methamphetamine.
That's not,
Do you have an attorney?
no, I don't.
Would you like one?
Yes, I would. That's horrendous.
All right. I will provisionally appoint the Office of the Public Defender. Just give me a moment to review the affidavit.
Yeah, it's,
All right, Mr. Roth, I have reviewed the probable cause affidavit, and I do find probable cause for all three offenses. That's resisting without violence, possession of drug paraphernalia, and possession of methamphetamine. I'll impose a $1,000 bond on the resisting charge, $2,000 bond on the possession of drug paraphernalia, and a $10,000 bond on the possession of methamphetamine. I will also impose pretrial release in the event that you do bond out. You are ordered to not use or possess any illegal drugs. You also will have random urinalysis screening at your own expense. Thank you.
Thank you.
Next up is Royston, Royston Williams.
All right, Mr. Royston, you are here, it looks like, on 3 counts of aggravated assault on a firefighter or emergency medical technician, 1 count of battery on a law enforcement officer, 1 count of resisting an officer with violence, and 3 counts of resisting an officer without violence. Do you have an attorney?
No,
Would you like one?
yes,
I'll provisionally appoint the office of the public defender. Just give me a moment while I review the probable cause affidavit.
No, there are 2 affidavits in this one.
Okay, all right, thank you. Okay.
cut-
Can you go back? Yeah, for the next one.
May I speak, Judge?
Nope, just hold on 1 second, please. All right, Mr. Royston, I've reviewed the probable cause affidavits, and I do find probable cause for all of the offenses. That would be 3 counts of aggravated assault on a firefighter or emergency medical technician, 1 count of battery on a law enforcement officer, 1 count of resisting an officer with violence, and 3 counts of resisting an officer without violence. I will impose a $15,000 bond on each of the counts of aggravated assault on a firefighter or emergency medical technician, a $15,000 bond on the battery of a law enforcement officer, $5,000 bond on the resisting officer with violence, and $1,000 bond on each of the resisting officer without violence charges. If you were to bond out on those, you will have pretrial release. You are not to use or possess any illegal drugs. You will also be subject to random urinalysis screening at your own expense, or excuse me, strike that. Strike both of those.
Yeah, have you heard on conditions change?
Yes.
I respectfully suggest a mental health evaluation in order to follow any recommended treatment.
I'll grant that request. So for pretrial, I will order that you seek a mental health evaluation and follow any recommended treatment. And is there a specified time?
No, ma'am, not from first appearance. None recommended by the state, I should say.
Your Honor, I believe you appointed us, is that correct?
Yes.
Then I'm going to ask Mr. Royston not to say anything on the record. We'll be out to talk to him so that we can represent him and hear everything he has to say. It's just right now, it might hurt him if he does so.
Mr. Royston, please listen to the advice that your provisionally appointed public defender has given you.
I do. I just have one question.
We can, actually, if it's not about, is it about the facts of the case? Because it's best not to talk about those right now. We can come out and answer any questions that you have for us, okay?
Oh, okay. When do I see you?
We'll send somebody out in a day or two to come chat with you first to get some information from you. And then the attorney will be in charge, okay?
This is my.
Don't say anything else about the facts of your case, Mr. Royston, okay?
Okay.
All right, thank you.
I'm not. I'm just saying, this is my first time here.
Sanchez Angel is next.
Go ahead.
First appearance.
Step aside,
Thank
Mr.
you.
Royston, thank you.
I'm sorry, what was that second name?
Sanchez.
Okay. yeah,
Good
thank
afternoon,
you.
Your Honor.
Is this Angel Lazaro Sanchez, is that correct?
Yes.
Mr. Sanchez, you are charged with one count of culpable negligence, exposing to harm, and also another count for shooting a missile into a dwelling, vehicle, building, or aircraft. Do you have an attorney?
No.
Would you like one?
Yes, please.
Okay, I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the probable cause affidavit. All right, Mr. Sanchez, I've read the probable cause affidavit, and I do find probable cause for both the charge of culpable negligence, exposing to harm, and shooting a missile into a dwelling, vehicle, building, or aircraft. On the culpable negligence charge, I will impose a $250 bond. On the shooting a missile into the dwelling, vehicle, building, or aircraft, I'll impose a $15,000 bond. Were you to bond out on those, you will be put on pretrial release. As a condition of that release, you are prohibited from using, possessing, or carrying any firearms, guns, weapons, ammunition, or knives.
Judge, may I stand and request GPS with house arrest because of the nature of the charges and the factual allegations? State would ask that he would be able to keep track of where he is, and we'd also request no contact with the location or the named victims.
Your Honor, we would object to the GPS. This looks like somebody who is trying to defend their home. If there hadn't been that other home nearby, please don't talk. If there hadn't been that other home nearby, this wouldn't even be an issue because he was trying to protect his home. There wasn't any cause for harm that he wanted, just because the police couldn't have video evidence that there was a crime about to occur didn't mean a crime wasn't about to occur. The reason we have handguns and we have the Second Amendment is to protect ourselves, and that's what he was doing. Thank you.
As another condition of your pretrial release, I am going to prohibit you from having any intentional contact with the victims. And that includes directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and or school at all times. You must also stay 500 feet away from the event location. I am not going to impose the GPS monitor at this time. Thank you.
Let's see. Next is Smith Travis.
All right, Mr. Smith, you're here on a charge of burglary, unoccupied structure, unarmed, destroying or harvesting palmetto berry without permission, and grand theft, over $750, but less than $5,000. Do you have an attorney?
No,
Would you like one?
yes.
I'll provisionally appoint the office of the public defender. Just give me a moment, please, to review the probable cause affidavit.
I think nothing would show it. Yeah. So what?
Thank you.
It seems there's a warrant that has the bonds amounts already set.
Yes, that's what I was reviewing. All right, looks like these were charges based off a warrant from Judge Hill. Is that correct?
There's a warrant, Judge, I'm looking for the signature page. I don't have that scan, I'll have to look up in some.
All right, yes, it looks like it was Judge Hill.
Just
All right. I have reviewed the affidavits, and I do find probable cause for all three charges. I will impose a bond of $5,000 on all three of those charges. All right, thank you.
Next is Trudell.
Hold on, can you bring back Mr. Smith? I'm sorry.
All right, Smith. Dick, we need Smith back. Yeah, we need Smith back.
All right, Mr. Smith, if you are able to bond out, I am going to impose pretrial release with certain conditions. That's going to be a curfew from 10 p.m. to 6 a.m., not to use or possess, carry any firearms, guns, weapons, ammunition, or knives. And you're also going to be prohibited from having any intentional contact with the victims, directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and/or school at all times. You also must stay 500 feet away from the event location. Thank you.
Sure, I think you have Devin Trudell.
Is this Mr. Trudell?
Yes. He was brought, my understanding, mental health and absence of offender, my understanding that his new charges were dropped, and I have a copy of that. I'm not sure if he's been released on those charges. From looking at the website, it looks like he was released in the kidnapping, but not the domestic battery, but state dismissed both of those cases. So he needs to be released on the charges here, to make sure he's done that. And then again, see if the county, that Broward County is going to pick him up on the out-of-county charges.
Do we know how long he's been held, or if they've been notified previously that we have him?
I don't know
Yes.
if he had.
Just one moment, please, Mr. Trudell.
Trudell, you said they were noticed before?
Yes, ma'am. Hey, Jan, how you doing? I was brought last week. They gave me 7 days and told me if Tampa didn't come get me, they'd release me. He said that Tampa should come get me because they so close. They just to skip over, and if not, it's a good thing because they haven't. So I'm here today, and hopefully,
See if it's, okay, let me
I
just,
I was the ASA last Friday, that was not with the court. Respectfully, that wasn't the court statement. As far as the procedural posture, I do not have a way of knowing whether Hillsborough was contacted, because again, that doesn't flow through my office. As I know the court's aware, once he's released in Polk, typically classifications will reach out and let Hillsborough know that he's available to be picked up. I do not have a way of knowing that directly. Again, as with the other cases, I can inquire, and I don't want to get too far off track, but before we let South go, I did receive more information from classifications already regarding Mr. Cabezas, who was earlier in the docket. The best I can offer to do is reach out to classifications and ask if they will kindly check and let me know what they have. Usually the again, I don't know, but usually the communications with Hillsborough is pretty good and pretty fast, as opposed to some other counties. But beyond that, I don't have direct information to provide.
Okay, let me just go through the procedural aspect of this first, because I didn't get a chance to even address him. All right, Mr. Trudell, you're here on an out-of-county warrant out of Hillsborough County of felony battery. I know the public defender has represented that you have previously been appointed. Was that on the new charges?
well, the charges that we've had, my understanding is that they've been no billed. So we were just gonna ask for him to be RR'd on those because the website hasn't released on one, but not released on both. And since they've been no billed, he should be released on both of those. That may then cause them to contact the county to make sure that the county is aware that he needs to be picked up.
Okay, but you were appointed on those new charges? Like he's,
I don't know.
okay. Let me go ahead and ask him about this charge. Mr. Trudell, do you have an attorney?
I did have one.
Was this a private attorney?
Natalie Owens, I believe, with the public defender office. My charges was no bill, so I don't know about any other attorney.
Natalie Orphy was the defense attorney in CF 26-2790 in Polk County. I'm looking now to see if I can get a disposition date and stack. I don't want to talk over this.
I can, if I can approach, I can show you the no cross that I took off the website.
Hey, Your Honor, may I say
Please,
something?
please don't say anything about the substance of your charges, please.
And let her read something.
Yes, ma'am.
Do you have this one pulled up? Counties, no, this is the charges that were here in Polk. The new charge that that's not cost.
We don't have that unless I look it up. We go by what's on the first appearance. If it was 26, yeah. So the last thing in there was no bill. Okay. No bill on 7/30/2026.
And you said he was still being held on one of these charges?
It looked like from the website on the Polk County Sheriff's Office that he was.
I can't confirm the state as no bill counts 1 and 2 on July 29th,
Okay.
or no cross.
All right. And then can you bring up his warrant in this one, please? In terms of this case, Mr. Trudell, would you like the Office of the Public Defender provisionally appointed for you?
Actually, we can't be appointed.
Oh, you're right. I'm sorry about that because it's an out-of-county warrant. I would not be able to do that. So just give me 1 second while I look over this affidavit, Mr. Trudell.
Yes, ma'am.
All right, I have reviewed the affidavit, Mr. Trudell. In terms of your out-of-county warrant, I am going to find probable cause still on that and continue to hold you for 1 more week to see if they do pick you up. So you'll be brought back to first appearance on that charge. However, on the charges here in Polk County, I do have the notice of null pros, and the state attorney has advised me that those were in fact null pros. So to the extent that you're being held on those, you are released on your own recognizance on those.
And
Yes,
for
ma'am.
that's 26 CF 2790.
That is correct.
Yes, ma'am. Your Honor, may I speak? For a
Not
second.
anything about the substance of your charges.
No, ma'am, because those over with, I have no reason to speak on those at all. I was just wondering, I know school's coming up, on the 11th. I was trying to make it out for the first day of school. I was wondering if I may be released and I can report to Tampa, early in the morning, Monday morning, or something like that. I mean, even if I had to be on pretrial or however, the report there and go through the process, like I would surely be there if that's an option or whatnot. I just wanted to be out for my kids and things like that.
Well, I do understand your request, Mr. Trudell. I'm going to deny that request. You're going to be held no bond for 1 additional week to see if Hillsborough picks you up.
Yes, ma'am. Have the courts heard anything from Hillsborough?
What was that?
Not that we know of it at this time. We're checking into that.
The public defender has advised me that they have not received any information about Hillsborough at this time. All right,
Okay.
thank you, Mr. Trudell.
Thank you. Welcome. God bless.
Next is Wallace Javante.
All right, Mr. Wallace, you're charged with one warrantless violation of probation on robbery with no gun or deadly weapon, attempted robbery, I should say. And then the other charge is domestic violence battery, touch or strike. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll go ahead and provisionally appoint the office of the public defender.
Thank you.
All right,
I'm
give me
trying
one
to figure
moment.
out.
Don't say anything about the substance of your charges, please. Give me just one moment to review the probable cause affidavit. All right, Mr. Wallace, after reviewing the probable cause affidavit, I do find probable cause for both the warrantless violation of probation, robbery with no gun or deadly weapon attempted, and then also the domestic battery, touch or strike. Counsel, did you want to be heard on this? I saw you start to approach, so I just wanted to make sure.
Wanted to make sure that he doesn't say things that will hurt him. Were we appointed?
Yes, I provisionally appointed you.
They're just standing close by in case that happens.
Okay.
Thank you.
All right. Mr. Wallace, on the charge of domestic violence battery, I would impose a $2,000 bond on that, and also prohibit you from having any intentional contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. Defendant, you must stay 500 feet away from the victim, victim's home, vehicles, places of employment, and school at all times. And you must also stay 500 feet away from the event location. And those would be conditions of your pretrial release. However, because you do have the violation of probation, you will be held on no bond.
Is the new charge a felony, ma'am? That's what I'm trying to figure out.
It's a misdemeanor at this time.
Okay, this charge is on my legal wife, the woman I'm married to.
Don't speak about the substance of your case, sir.
Okay, please just let us do our jobs. We will have someone come see you and talk to you about what your options are, okay?
Okay.
We're just trying to protect it. Thank you so much.
Thank you.
Yes, ma'am.
Last one we have is Zavala.
Jose Zavala, is that correct?
Yep.
All right, Mr. Zavala, you are here on a charge of battery on a law enforcement officer, resisting an officer without violence, threatened death or harm to a law enforcement officer or state attorney, resisting an officer with violence, leaving the scene without giving information of more than $50 in damage. It looks like you have 2 counts of that, leaving a scene without giving information more than $50 in damage. You also have 2 counts of DUI property damage or personal injury, 1 count of DUI, and 1 count of refuse to submit to a blood or alcohol test or breath or alcohol test. Do you have an attorney?
No, I don't.
Would you like one?
Yes, Your Honor, please.
Okay. I'll provisionally appoint the office of the public defender. And just give me a few moments while I review the probable cause affidavit. First affidavit. Okay. Is the second one not here? Yes. You keep scrolling.
All right, Mr. Zavala, having looked over the probable cause affidavit, I do find probable cause on all the counts: battery on a law enforcement officer, resisting an officer without violence, threatening death or harm to a law enforcement officer or state attorney, resisting an officer with violence, 2 counts of leaving the scene without giving information, more than $50 in damage, 2 counts of DUI, property damage and personal injury, 1 count of DUI, and 1 count of refusal to submit to a blood and alcohol test. On the charge of battery on a law enforcement officer, I will impose a $5,000 bond. On the charge of resisting an officer without violence, I'll impose a $1,000 bond. On the charge of threatening death or harm to a law enforcement officer or state attorney, I will impose a $2,000 bond. On the charge of resisting an officer with violence, that will be a $5,000 bond. On the 2 counts of leaving the scene without giving information, more than $50 in damage, I will impose a $250 bond. On the charge of DUI, property and personal damage, that will be a $2,000 bond on each of those counts. On the DUI, that will be a $1,000 bond, and on the refusal to submit to blood and alcohol testing, that will also be a $1,000 bond. Should you bond out on those, you will be put on pretrial release, and you are not to consume or possess any alcohol or enter any bar or lounge. You will be subject to random urinalysis and breath testing at your own expense. State any other conditions that you'd be requesting?
No, Your Honor, thank you.
All right, thank you, Mr. Zavala.
Thank you. You have a good day, Your Honor.
That's all we have, Sal.
All right, thank you. All right, and we'll start with the females over at Central, please.
Stacy Campbell.
Ms. Campbell, we have you here on operating while driver's license revoked for habitual traffic offender, and then also a violation of the financial responsibility law. Do you have an attorney?
No, ma'am.
Would you like one?
Yes.
I'll provisionally appoint the office of the public defender. I did want to inquire, I see an open case, it looks like a criminal traffic case. That's 26-5, CT 5477.
Yes, ma'am. That was a uniform traffic citation with a summons, so there was no bond or pretrial release condition. State's position is it does not qualify for a park rule.
All right. Ms. Campbell, I have reviewed the probable cause affidavit in this case. I do find probable cause. I'm going to impose a $5,000 bond on the operating while driver's license revoked as a habitual traffic offender, and a $500 bond on the violation of financial responsibility law. If you do bond out, you will be subject to pretrial release. And as a condition of that pretrial release, you are prohibited from driving without a valid driver's license or permit. Thank you.
Thank you.
Tammy Colbert.
Ms. Colbreth, we have you here for 1 count of DUI, alcohol or drugs, and 1 count of DUI, property damage or personal injury of another. Do you have a attorney?
No, ma'am.
Would you like one?
Probably later on, not right now.
Okay, are you going to hire your own attorney or represent yourself?
No, I was gonna hire one.
Okay, so for purposes of today, though, you want to go ahead with first appearance today, or did you want 24 hours to try to attempt to hire an attorney and come back tomorrow?
No, ma'am, we can go ahead today.
Okay. All right. I have reviewed the probable cause affidavit in this case, and I do find probable cause. I'm going to impose a $1,000 bond on the DUI, alcohol or drugs, and a $1,000 bond on the DUI with property damage or personal injury of another. If you do bond out on those, you will be subject to pretrial release. You are ordered not to engage in any criminal activity. You are also ordered not to possess or consume alcohol or enter any bar or lounge. And you will be subject to random urinalysis testing and breath testing at your own expense. Thank you.
Okay, thank you.
Gigi Graham,
We'll ask to be heard on this one.
Okay. Ms. Graham, you are charged with DUI with a blood and alcohol content over 0.15 or a passenger under 18 years of age. You're also charged with resisting without violence. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. Please just give me a moment to review the probable cause affidavit.
Yes, ma'am.
Okay. Is the resisting or we separate? I don't see it on this. You can what? I can add it. Okay.
Oh, sorry.
Approve that resisting charge. This is what I have here.
Sure. Yes, ma'am.
All right, state. You wanted to be heard on this one?
I would just ask the court, well, I guess two things. One, to presuming a finding of probable cause, the state is going to request that the accused be held no bond pursuant to Parker and CF 26-4339, and considering the charge in that case, I take that into consideration in setting a bond in the case before the court today.
About the one that was on.
It's background talking. I already provisionally appointed on this one, right? Okay, all right. Do you have any position, counsel, on? All right, Ms. Graham, I did find probable cause for both of these charges against you, DUI with a blood and alcohol content over 0.15 or passenger under 18 years of age, as well as resisting without violence. I will impose a $5,000 bond on either of those charges. Were you to bond out on those charges, you would be required not to possess or consume alcohol or enter any bar or lounge. You would also be subject to random urinalysis screening. However, based on your current pretrial release in the other case, I will revoke that pretrial release pursuant to Parker v. State, and you will be held no bond.
Can I ask a question, ma'am?
Not about the substance of your case.
How does that work? Do I go to another court hearing as far as that?
You would have a follow-up hearing, yes. Your next
Would-
hearing, do we have next hearing date or no?
For this one, it's,
It'll be September 22nd.
You said September 22nd, 8:30.
9:30 at the time, so I'm thinking.
As currently scheduled, your next hearing will be September 22nd at 8:30.
Okay, thank you, ma'am.
Who's next, please?
Sheila Harmon.
Sorry, can I get that name again, please?
I'm sorry, say that again.
Can I get that name again, please?
Sheila Harmon.
Thank you.
All right, Ms. Harmon, you are charged with petty theft, your third or subsequent offense, and also resisting an officer without violence. Do you have an attorney?
No, ma'am, but I've never been charged with that before.
Okay, please don't say anything about the substance of your case. Would you like an attorney?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. Just give me one moment while I review the probable cause affidavit.
Yes, ma'am. Ow.
Well, you still have to pick.
Please stop speaking, whoever's speaking in the background.
Showing history on
All right, Ms. Harmon, having reviewed the probable cause affidavit, I do find there's probable cause for both the charge of petty theft, third or subsequent offense, and resisting an officer without violence. I will impose a $5,000 bond on the petty theft charge and a $1,000 bond on the resisting an officer without violence.
Ma'am, can I ask a question?
Don't ask anything about the substance of your case.
I just want to know my court date, my next court date. I have something going on with my foot and I could die behind it. I have a bone infection and I need to go to have surgery.
All right, your next court date will be September 8th at 8:15.
Okay, thank you.
Thank you.
Penelope Huggins.
Can you say that last name again?
Huggins.
All right, Ms. Huggins, you are here on a charge of resisting an officer without violence. And what?
To officers. Law enforcement officers.
This is an add-on charge. So is she currently on pretrial for anything? All right, Ms. Huggins, after reviewing the information we have on file, including this information, I do find probable cause, and I will impose a bond amount in the amount of $10,000. Thank you.
I don't think she was appointed counsel.
Oh, I'm sorry. Ms. Huggins, do you have an attorney?
No.
Would you like an attorney? I'm sorry, did you say yes?
I would help with her. There are some issues with this client that I've just noticed that may make it difficult for her to answer you.
Okay.
So we would ask to be appointed. Already been appointed.
Okay.
Thank you.
Ms. Huggins, I'm going to provisionally appoint the Office of the Public Defender for you.
Kendall Jackson.
All right, you may step aside, Ms. Huggins.
Kendall Jackson.
All right, Ms. Jackson, you are charged with domestic violence, battery, touch, or strike. Do you have an attorney?
No, Your Honor.
All right, would you like one?
Yes, Your Honor.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment to review the probable cause affidavit. All right, Ms. Jackson, having read the probable cause affidavit, I do find probable cause on the charge of domestic violence, battery, touch, or strike. I'm going to impose a $2,000 bond. However, if you are to bond out, you will be subject to pretrial release. And you have several conditions on that. That will be to not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You're prohibited from having any contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and school at all times. You're to stay 500 feet away from the event location. And based on what I've read, I'm also going to order you to complete a mental health evaluation and follow any recommendations that are made during that.
Yes, Your Honor. I had an evaluation this morning, or is that not what you mean?
That will be subject to the pretrial release. So if you've already had that, you can certainly talk to the public defender and they can provide further information to the court at your next court date.
So am I still able to bond out or no?
You were given a $2,000 bond amount, and then if you do bond out, you'll be subject to all those pretrial conditions that I just listed.
Yes, ma'am.
All right, thank you.
Maria Jones.
Ms. Jones, you are charged with domestic violence, battery, touch, or strike. Do you have an attorney?
No.
Would you like one?
Yes.
All right, I'll provisionally appoint the Office of the Public Defender. Yes. All right. I have reviewed the probable cause affidavit in this case, and I do find probable cause for the domestic violence, battery, touch, or strike. I am going to impose a $500 bond. If you do post that bond, then you'll be subject to pretrial release with the conditions of not using or possessing or carrying any firearms, guns, weapons, ammunition, or knives. And you will be allowed to have contact with the victim, but you are prohibited from being physically or verbally threatening, violent, or abusive in any manner whatsoever. Thank you.
Renee Love.
All right, Ms. Love, you're charged with possession of drug paraphernalia and also possession of methamphetamine. Do you have an attorney? Ma'am, do you have an attorney?
No.
Would you like one?
Yes.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the probable cause affidavit. All right, having reviewed the probable cause affidavit, I do find probable cause for both the possession of drug paraphernalia and possession of methamphetamine. On the charge of possession of drug paraphernalia, I'll impose a $1,000 bond, and on the possession of methamphetamine charge, I'll impose a $5,000 bond. Were you to bond out on those charges, you'll be subject to pretrial release. You are ordered not to use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you.
Yohani Ortiz.
Ms. Ortiz, you are charged with, it looks like a warrantless violation of probation for disorderly conduct and breach of the peace, and also a warrantless violation of probation for resisting a law enforcement officer. I think that's without violence, is that correct? This is Yohani Ortiz. These are
warrants out of, looks like maybe Vanillas.
Hold up at that door. Don't stop at that door.
That's why I looked up there and I see that. It looks like the complaint and arrest affidavit is out of Pinellas. Are these our charges? Are these ours? Did I see them in the? These are our charges. Okay, so they're from this county, correct? Okay. All right. Do you have anything else? All right, Ms. Ortiz, based on the violation of probation, I've read the information in our file, and I do find probable cause for both the warrantless violation of probation, disorderly conduct, breach of the peace, and warrantless violation of probation, resisting law enforcement without violence. Did I already appoint the public defender?
No, she has a private attorney.
Private attorney.
Douglas Fryer.
Okay, and you have a private attorney, is that correct?
Yes, Your Honor. I believe he was on the call at one point.
Do you have any name? Do you have the private attorney's name?
I do not have one listed in stack.
Mr. Pryor, are you on the call today? Ms. Ortiz? It does
Yes, Your
not,
Honor.
if you have private counsel, it does not appear that he is here, at least at the moment. Did you want to reset this for tomorrow so that you could have your counsel present?
No, Your Honor.
Okay, so you're ready to continue to go ahead with this today?
Yes, Your Honor.
All right, because these are violation of probation charges, you will be held no bond on both of those charges.
Yes, Your Honor.
You may-
I have one question. Is my court date still set for September 1st? I received that in legal mail today.
Yes, you'll still
Thank
be
you.
here. Thank you.
Deanna Patton?
What did you have there? All right, Ms. Patton, you are here on a violation of probation for resisting without violence, violation of probation, possession of drug paraphernalia, and violation of probation, possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay, I'll provisionally appoint the office of the public defender. And based on these violation of probation charges, I do find probable cause, and you will be held no bond on all of those charges. Thank you.
Marilyn Pardo Miller?
Miller? Oh, Prado. Prado Miller.
PRA. Oh, thank you, thank you.
She has like the. First purge, maybe. All right. All right. Ms. Prado Miller, you are charged with failure to appear for arraignment for using or possessing drug paraphernalia and failure to appear for arraignment for misdemeanor possession of cannabis. Do you have an attorney?
No, ma'am, but I'd like to be provided for one.
Okay, I'll provisionally appoint the Office of the Public Defender. I do see that this is from a capias issued by Judge Patey. I do find probable cause, and you will be given a $1,000 bond on either of those charges.
All right.
All right, thank you.
Emily Schwab.
I'll ask to be heard on this one, Judge.
Okay.
She has it in Polk County. It's one of 7 pages long.
Okay. I can go back to her. All right, Ms. Schwab, you're charged with harassing as a first-degree felony and a first-degree felony proceeding. Do you have an attorney?
Your Honor, I believe the Office of the Public Defender does represent her.
Okay.
26, yeah, 7562.
They're muted. All right, Central, can you unmute yourselves, please?
Sorry.
No, sorry. So if you could appoint us to this as well.
Okay.
We're appointed to the other case with her.
All right, Ms. Schwab, I'm going to provisionally appoint the public defender for you on this case. State, you wanted to be heard?
Yes, Your Honor, with regard to CF 267562, I believe the allegation before the court in the instant matter is that the accused was released on pretrial release and bond in that case, and then I would argue immediately contacted victims in an attempt to manipulate their cooperation with that felony case. That felony case was before the court very recently on charges, 1 count of grand theft, 6 counts false information on pawned items, 12 counts of dealing stolen property, 8 counts of grand theft firearm, 6 counts false owner information to pawnbroker, and 1 count of possession of firearm by a convicted felon. All of those are F2s or F3s. I bring all that up to ask the court to consider the type of proceeding that underlies the charge before the court today. The brief amount of time that the accused had access to communications which to pick up this new first-degree felony, asked that she be Parkered in CF 267562, and that an order of no contact be issued for all victims listed. There are numerous, but they are in the affidavit in CF 267562 as a condition of pretrial release in the instant case. Thank you.
Your Honor, these are just accusations, and we've had very little time to look into anything like that, and it's until proven guilty. We just ask that she be given a standard bond.
And Your Honor, if I may say, I have not been released
I
today.
would actually ask her not to speak at all.
Yes, ma'am. Please do not speak about the substance of your case at all, please.
Yes, ma'am.
All right. Ma'am, I do find probable cause for the add-on charge of harassing felony first degree. I will impose a $50,000 bond on that charge. If you were to bond out as a condition of your pretrial release, you would be prohibited from contacting the victim directly or indirectly in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay away 500 feet from the victim's home, vehicles, place of employment, and or school at all times. You would stay away from 500 feet away from any event location. And due to the fact that you were on pretrial release in the other case, I will revoke that pretrial release and you will be held no bond per Parker v. State.
Yeah, and just so she understands, when you're talking about the conditions you just ordered, pretrial release, staying away from the victim, that also is in effect while she's in jail, so she can't contact from there as well.
That is correct, ma'am. You would have no contact with the victim even while you are in jail. That's directly or indirectly. Central, I think you're muted again. All right, do you understand, ma'am?
Yes, Your Honor.
All right, thank you.
Lisa Stankwith.
What's the last name?
What was that name?
Stanwyck.
I apologize for the call.
All right, Ms. Stanwyck, you are charged with a warrantless violation of probation for improper exhibition of a firearm or dangerous weapon. Do you have an attorney?
No.
Would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment. Based on my review of the record, I do find probable cause for the violation of probation, and you will be held no bond. Thank you.
Anisha Velez.
What was that last name again?
Velez.
Anisha. Okay, I see it. All right, Ms. Velez, you are charged with DUI with a blood alcohol content over 0.15 or a passenger under 18 years of age. Do you have an attorney?
No.
Would you like one?
Yes.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the probable cause affidavit. All right, Ms. Velez, having reviewed the probable cause affidavit, I do find probable cause for the charge of DUI with blood and alcohol content over 0.15 or a passenger under 18 years of age. I'm going to impose a $2,000 bond. If you are to bond out, you will have pretrial release. The condition of pretrial release, you are not to possess or consume alcohol or enter any bar or lounge. You'll also have random urinalysis screening at your own expense. Thank you.
Yes, ma'am. Thank you.
Amber Walker.
All right, Ms. Walker, you're
Ma'am?
charged with failure to appear at a competency hearing.
Ma'am, can I explain to you that my mail goes to my ex-fiance's house and he's trying to keep,
Ma'am, please don't talk about the substance of your case.
okay.
Do you
Okay, but
have
can
No, please don't say anything else about your case.
oh, no, I'm just gonna let you know, can you check the person's record? You'll see that she's a,
Ma'am,
yes?
Please take what she's trying to do is give you a reason that she might not have appeared because the mail went somewhere else. But
Yes.
that was probably the substance of what she was trying to say. And the judge is now going to consider that.
Okay. Ma'am, do you have an attorney?
No, ma'am, I don't.
Okay. Would you like an attorney?
Yes, ma'am.
Okay. I will provisionally appoint the office of the public defender. And just give me one moment while I review the documents in your case.
When's my next
Just one moment, ma'am. Let me finish,
Okay,
please.
okay, I'm sorry.
All right, ma'am. This is KPS that was issued by Judge Patey. I do find probable cause, and at this time, I am going to hold you no bond on this charge. When's her next court date?
The next court date is August 13th at 8:30.
Your next court date is August 13th at 8:30.
Ma'am. Okay.
Thank you, ma'am.
Sherelle Ward.
All right, Ms. Ward, you are charged with operating while your driver's license is suspended, canceled, or revoked. First conviction. Do you have an attorney?
No, ma'am.
Do you like one?
I'm gonna say yes. I'm not sure if I need one or not, but I'll say yes.
Okay. I'm going to provisionally appoint the office of the public defender. Just give me one moment while I review the documents in your case. All right, Ms. Ward, having reviewed the documents, I do find probable cause for the charge of operating while driver's license suspended, canceled, or revoked. I'm going to impose a $1,000 bond. Should you bond out, you will be subject to pretrial release with a condition that you are prohibited from driving without a valid driver's license or permit. Thank you.
Thank you.
Crystal Woodard.
What was your last name again, ma'am?
Woodard.
All right, Ms. Woodard, I see that we have you on a charge of violation of probation for possession of methamphetamine. I have reviewed the documents in this case. I do find probable cause. Do you have an attorney?
No, ma'am.
Would you like an attorney?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. Because I have found probable cause for this violation of probation, you will be held no bond.
When's my next court date?
September 1st. At what time? At 8:30. All right. September 1st at 8:30.
Thank you.
Thank you. Before we start on the mails, I'm going to go ahead and take a brief recess for a comfort break.
All right, so it'll be a 10-minute recess.
All rise.
Seniors. Yes, I have that. Lashanda? Yeah. Oh, Scott. Name wasn't called. We don't know where she. Meaning, we don't know the location of where she's at? Looks like she's there, central. Same with Warren there. You said Warnock? Okay. Central, I have a question for you about 2.
Yes, ma'am.
Erica Renee Warnock. We had her on our list.
Warnock stayed in the dorm because she was sick.
We'll go ahead and set her for tomorrow. And then we also had Lashunda Scott.
LaShonda Scott is in medical.
In medical, okay. All right, we'll reset her for tomorrow as well. All right, you may go ahead, Central.
Ms. Abercrombie, Amber, Reed.
All right, Mr. Abercrombie, we have you here on 1 charge of DUI, alcohol or drugs, resisting arrest without violence, or resisting without violence, possessing or using narcotic paraphernalia, and then also possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay, I'll provisionally appoint the Office of the Public Defender. I have previously reviewed the affidavits, and I do find probable cause on all 4 of those charges. On the DUI, alcohol or drugs, I will impose a $1,000 bond. On the resisting without violence, that will be a $2,000 bond. The possession or use of narcotic paraphernalia will be $2,000 bond. On the possession of methamphetamine, that will be a $10,000 bond. Should you bond out, you will be subject to pretrial release, and you have the following conditions. You are not to use or possess any illegal drugs. You are subject to random urinalysis testing. You're not to possess or consume alcohol or enter any bar or lounge. And I believe that's all. So thank you.
What's that?
Do we have a name?
Oh, Jimmy Andriel.
All right, Mr. Andriel, I see here we have you on a violation of probation for possession of cannabis, violation of probation for possession of drug paraphernalia, violation of probation for a threat to a law enforcement officer. Do you have an attorney?
Yes, I do.
All right, is this a private attorney?
Yes, it is.
Okay. Do you know if they're on today? Can you give me their name?
Yeah, I got court Monday. She'll be there Monday.
Okay, but you're not aware that she is here today for first appearance?
No, I already talked to her yesterday.
Okay, and you are fine to go ahead with this first appearance hearing even though she is not present?
Yes, ma'am.
Okay, all right. I have previously reviewed the affidavits violation of probation. I find that there is probable cause for all 3 of those counts and you will be held no bond.
Yeah.
All right, thank you.
Michael Barrett.
Mr. Barrett, we have you on a warrant from Glades County, it appears, for violation of possession or violation of probation for possession of paraphernalia. I cannot appoint the Office of the Public Defender for you as that is an out-of-county warrant. But I did previously review the information that we have. I did find probable cause, and you will be held no bond on that, sir.
Okay, when do I go to court?
That would be up to Glades County because that's where this charge is coming out of. So you're being held pending for them to pick you up.
Okay, thank you.
Belila, Big,
Can you say that last name again?
Belila, Bilila.
Letter B-E-L.
B as in boy.
B as in boy.
All right. Okay. All right, Mr. Belila, I also have you on an out-of-county warrant out of Pasco County. It's misdemeanor failure to appear for battery, touch, or strike. Because that is an out-of-county warrant, I cannot appoint the Office of the Public Defender for you. I have previously reviewed, however, the warrant information that we have. I did find probable cause, and you will be held no bond.
I have an attorney over there, Scott Tremblay. He's my attorney, and am I going to be transported to Pasco? I don't have any charges here in Polk.
Pasco will be notified that you're being held here for them to pick you up. So, and you'll be brought back to first appearance on August 14th if you're still in custody with us.
Okay.
All right, thank you.
Okay.
Danny Bermia.
Mr. Bermia, you are charged with a warrantless violation of probation for use or possession of drug paraphernalia. One charge of possession of drug paraphernalia, that's a new charge. A new charge of possession of methamphetamine, a warrantless violation of probation for resisting or obstructing an officer without violence. And then it looks like a new charge of tampering with a jury. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay, I'll provisionally appoint the Office of the Public Defender. And I see counsel that you want to be heard on this one.
Yes, Your Honor. In tampering with the jury, I don't see any PC for that one, so I would challenge that.
I see no mention at all of any facts that are even directed toward that charge in the affidavit. Also, with great respect to the case filing agent, the conclusion I've come to based on the information that is the affidavit that may have been added an error. If it turns out that's not the case, it won't affect whether the state can charge it. But at this point, I am not requesting 24 hours to perfect, as I don't see an affirmative reason to think that that can be perfected in 24 hours.
So in other words, you're agreeing to an ROR on that
Yes,
charge? Okay, all right. All right, I did previously review the documents and I did also see that issue with the probable cause on that charge. So I'm going to find that there's no probable cause on the tampering charge and you'll be released on your own recognizance on that charge. On the new charges of possession of drug paraphernalia and possession of methamphetamine, I do find probable cause on those. On the possession of drug paraphernalia, that will be a $1,000 bond. On the possession of methamphetamine, that will be a $5,000 bond. If you were to bond out on those, you would have pretrial release with the condition that you would not use or possess any drugs, and also that you'd be subject to random urinalysis screening. However, because you have 2 warrantless violations of probation, you will be held no bond on those charges. Thank you.
Thank you.
Sheldon Bowman.
All right, Mr. Vaughn, it looks like you have a felony violation of probation warrant out of Georgia. And it looks like, I guess that's all you have before us, but because that is an out-of-state warrant, I cannot appoint a public defender for you. So I don't know if you were going to hire your own attorney or choose to represent yourself.
I have no charges here in Polk County.
Okay, all right. Then I did look over that previously. I found probable cause and you'll be held no bond on that.
All right.
All right, thank you.
Andre Breathwaite.
Mr. Breathwaite, I have an out-of-county warrant out of Lake County for violation of possession of cocaine less than 28 grams. Do you have an attorney?
No.
Looks like because it's out of county, I cannot appoint a public defender for you. And I did find probable cause based on that out-of-county warrant for violation of probation. You will be held no bond.
Does it say what the violation is?
It just says a warrant for violation of probation, the underlying charge, possession of cocaine less than 28 grams.
So there's no, it doesn't state what the violation is exactly?
This, all the information I have is that it's a violation of probation warrant out of Lake County.
Okay. So at first appearance, when I go to Lake County, will they have more information from me?
Yes.
Okay.
All right.
All right.
Thank you.
Nelson Bustos.
Mr. Bustos, you are charged with DUI with a blatant alcohol content of 0.15 or passenger under 18 years of age. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the office of the public defender.
Can I say something, Your Honor?
Not about the substance of the charge. Just give me a moment to look over
Okay.
something real quick.
Okay.
Per classifications, we weren't able to verify his.
But we don't know. We don't see anything indicating that there's any kind of detainer or anything on him. Okay. Okay. All right, Mr. Bustos, I have previously reviewed the documents and I did find probable cause for the charge of DUI with a blood and alcohol content of 0.15 or a passenger under 18 years of age. I am going to impose a $2,000 bond. If you were to bond out, you would be put on pretrial release with the conditions that you are not to possess or consume alcohol or enter any bar or lounge. You would be subject to random urinalysis screening at your own expense.
Thank you.
Thank you. Can I get a name for this one, please?
Mark Clark.
All right, Mr. Clark, it looks like we had a warrant from Judge Harb. This was for a charge of grand theft of a motor vehicle as well as burglary of an unoccupied conveyance. Unarmed. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Okay, I'll provisionally appoint the office of the public defender. Is he on any kind of pretrial or conditional release?
I think this is actually his
Person. I saw something, but maybe it didn't.
He has quite a amount of JV, but nothing for
All right. Based on everything that I've looked at and the affidavits that are in our file, I did find probable cause on both of those. So I'm going to impose a $5,000 bond on each of those counts. If you were to bond out, you do have conditions of pretrial release. That includes to not engage in any criminal activity. Also, to not use, possess, or carry any firearms, guns, weapon, ammunition, or knives. You're prohibited from having any intentional contact with the victims. That's directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, directly or indirectly, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and schools at all times. All right, thank you.
Yes, ma'am. Thank you, Your Honor.
James Davis.
Mr. Davis, you're charged with tampering with physical evidence, resisting without violence, possessing or using narcotics paraphernalia, possession of methamphetamine, and fleeing or attempting to elude a law enforcement officer. Do you have an attorney?
No.
Would you like one?
Yes.
I'll provisionally appoint the office of the public defender. And we're just checking on something. Okay. Let me look back over something that I didn't see earlier to make sure about something.
Guys, let's rub back.
And what you gonna say?
I'm in the big stuff. Well, you have one up and then that speed seven in the seven. You got me too? Yeah. Right. Y'all wait. Everybody's waiting. Y'all, you hungry? You better get going.
All right, I did find, after reviewing the affidavits, I did find probable cause on the resisting without violence, the possession or use of narcotic paraphernalia, the possession of methamphetamines, the possession of methamphetamine charges, as well as the fleeing or attempting to elude the law enforcement officer. State, I did have a question about the tampering with physical evidence charge. If you could look at that for me.
Yes, ma'am. Judge, I would acknowledge after reading a lengthy affidavit, I did not see the factual basis that the officer was alleging. That is charged as a third-degree felony. On that count, I will request 24 hours to perfect.
Okay. And counsel, any response from you?
Yes, Your Honor, we would just ask you to find no PC.
What I'm going to go ahead and do then, rather than separate the charges, I am going to just roll this over for 24 hours for tomorrow to give you the opportunity. All right, Mr. Davis, we'll see you again tomorrow.
Man, how we get this done today? Can't get.
We'll see you tomorrow, Mr. Davis.
Ma'am,
All right, can you say that name again, please?
Alvarez Echeverria.
Severia.
All right.
ECH.
Mr. Echeverria, you are charged with a violation of probation for possession of cannabis, marijuana, not more than 20 grams, violation of probation for resisting without violence, violation of probation for introducing contraband into a county detention facility, and violation of probation for use or possession of drug paraphernalia. Do you have an attorney?
No, I do.
You said you do or you do not?
I do not.
Okay. Would you like an attorney?
Yes, ma'am. As long as it's not Stewart.
I'm going to provisionally appoint the Office of the Public Defender. I have previously reviewed the affidavits in this case, and I did find probable cause. You will be held no bond on all of those charges.
Yes, ma'am.
Damian Farrell. Barry. Farr.
All right, Mr. Ferrier, you are charged with possession of cannabis or possession of drug paraphernalia, possession of cannabis resin, domestic violence, commit battery by strangulation, domestic violence, battery, touch or strike, and domestic violence, simple assault with intentional threat of violence. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. I have previously reviewed the affidavits in this case, and I did find probable cause for all of these. I do believe that those last three charges were from a warrant. Is that correct? Okay.
Yes, ma'am.
All right.
On March 9th, 2026.
Contact was made with the victim.
On the warrant. I just want to make sure I have it correct on the record. Oh, Judge Patey. Okay. All right. Judge Patey had the warrant on those last three charges, which were the domestic violence charges. Having reviewed everything in our file on the possession of cannabis charge, I'm going to impose a $1,000 bond. On the possession of drug paraphernalia, that will also be a $1,000 bond. The possession of cannabis will be a $5,000 bond. The domestic violence commit battery by strangulation will be a $10,000 bond. Domestic violence, battery, touch or strike will be a $1,000 bond, and domestic violence, simple assault or intentional threat of violence will be also a $1,000 bond. If you bond out, you are ordered not to engage in any criminal activity. You also are not to use or possess any illegal drugs, as well as be subject to random urinalysis testing. You are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You are prohibited from having any intentional contact with the victim, either directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, school at all times. You are to stay 500 feet away from the event location.
Yes, ma'am.
Thank you.
Please, so I got mine.
Yeah. Christopher Felker.
Yes, please. All right. What did she say the next name was? Is it?
Christopher Felker, Felker.
All right, Mr. Felker, you are charged with tampering with physical evidence, domestic violence, aggravated assault with a deadly weapon without intent to kill, domestic violence, battery, touch or strike, possession of drug paraphernalia with a container, and possession of methamphetamine. Do you have an attorney?
Nope.
Would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. State, do you have any recommendations on bond in this case?
Judge, with regard to the third-degree felonies, there is a standard bond for those. I would note that the named victim in this case is also on the docket. Though I believe not charged with violence, but only possession of the drugs. I would ask for $5,000 bond for each of the F3s. I would request pretrial release conditions with no contact with the victim.
You heard, counsel.
I would ask for if there was no contact, no violent contact, since they are a couple, so forth.
Just look over something really quickly.
One and two are kind of.
All right. Mr. Felker, I have previously reviewed the documents in this case. I do find probable cause on the tampering with physical evidence, domestic violence, aggravated assault with a deadly weapon without intent to kill, domestic violence, battery, touch or strike, possession of drug paraphernalia with a container, and possession of methamphetamine.
I am going to impose a $5,000 bond on the tampering with physical evidence charge, $5,000 bond on the domestic violence aggravated battery, or aggravated assault with a deadly weapon without intent to kill charge, $2,000 bond on the domestic battery, touch or strike, $1,000 bond on the possession of drug paraphernalia with a container, and a $5,000 bond on the possession of methamphetamine. If you are to bond out on those charges, you will have pretrial release. You are ordered not to engage in any criminal activity, not to use or possess any illegal drugs. You are also ordered to submit to random urinalysis screening. You're not to use or possess or carry any firearms, guns, weapons, ammunition, or knives. You are prohibited from having any intentional contact with the victim, directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, places of employment, and/or school at all times. You must also stay 500 feet away from the event location. Now, I understand that perhaps this is also your residence.
Yeah.
Is that correct?
Yes, ma'am.
Okay. And the victim also resides at that residence?
Yes, ma'am.
I will allow you at this point to return to the house within 48 hours, accompanied by law enforcement, to retrieve your personal belongings. This is obviously if you choose to bond out, and then you're subject to all the other named conditions that I already said.
Yes, ma'am.
All right. All right.
Yes.
Thank you.
So, thank you.
Shin Forward.
Mr. Fullwood, you are charged with knowingly driving while license suspended or revoked, first conviction. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. Just give me one moment while I look over the documents in this case.
Yes, ma'am.
One moment. Okay. What was that?
The charge that he's currently on.
No one was before.
So I don't know if it was a typo, but he's currently on bond for driving while license suspended.
Okay, it looks like it was a separate one. Okay, I just want to confirm with you both. It looks like he was on bond for at least a similar or the identical charge that occurred on August the 2nd. Do you have that?
This is for Fullwood.
This is for Fullwood, yes.
I just got it over there. Let me pull it.
It's 26 CT 6361. Yes. Do you know what his bond amount was in the case?
Yes, ma'am. I saw a bond being posted in that case on August 6th.
So he's already posted bond then, correct?
Yes, ma'am.
Yes, okay.
So request that bond be revoked.
Out of Parker.
Yes, ma'am.
All right. I have reviewed the documents in this case. Did I already appoint counsel on this one? Just want to make sure. I've already appointed public defender.
Asked it be reappointed again to make sure.
Okay, all right. Mr. Fullwood, do you have an attorney?
No, ma'am. No, ma'am. I don't have one.
Would you like one?
Yes, ma'am, please.
Okay, all right. I'm going to provisionally appoint the public defender. In this case, I have reviewed the probable cause affidavit, and I do find probable cause for this charge. I would impose a $1,000 bond on this charge.
Yes, ma'am.
And then if you did bond out on this charge, you would be subject to pretrial release, and you would be, the condition that would be imposed would be that you would not drive without a valid driver's license. However, you were recently on bond for a similar offense. So that bond will be revoked and you will be held no bond pursuant to Parker.
When is the next court date, miss?
One moment.
Next court date is August 28th at 8:30.
August 28th at 8:30.
All right, thank you.
All right, thank you.
Michael Gibson.
Mr. Gibson, you are charged with possession of cannabis, not more than 20 grams, possession of drug paraphernalia, possession of a controlled substance without a prescription, possession of methamphetamine, possession of concealed weapon by a convicted felon, and a second charge of possession of a concealed weapon by a convicted felon. Do you have an attorney?
No.
Would you like one?
Sure.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the charges.
Robert Holmes. Pardon? They're right there, Mr. Hall. Pardon?
Polk. Yeah.
I'm hearing a lot of background noise, so if you have your microphone on, please mute it. All right, Mr. Gibson, I have reviewed the probable cause affidavits. I do find probable cause on the charge of possession of cannabis, not more than 20 grams, possession of drug paraphernalia, possession of a controlled substance without a prescription, possession of methamphetamine, and the 2 counts of possession of concealed weapon by a convicted felon. On the count of possession of cannabis, I'll impose a $1,000 bond. On the possession of drug paraphernalia, that will also be a $1,000 bond. On the possession of a controlled substance without a prescription, that will be a $5,000 bond. The possession of methamphetamine will be a $5,000 bond. On both of the counts of possession of a concealed weapon by a convicted felon, that will be a $20,000 bond on each of those counts. If you were to bond out, you would be subject to pretrial release. That would contain the following condition: that you're not to engage in any criminal activity, you're not to use or possess any illegal drugs, You would be subject to random urinalysis screening at your own cost. And you are not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. Thank you.
Gibson, you're here. Robert Hall.
Mr. Hall, you are here on a
Yes.
possession of drug paraphernalia, a smoking device, and a possession of methamphetamine charge. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. Just give me one moment.
Okay.
All right, Mr. Hall, having reviewed the affidavit in this case, I do find there's probable cause for both of those charges. I will impose a $1,000 bond on the possession of drug paraphernalia charge, as well as a $5,000 bond on the possession of methamphetamine. If you are to bond out, you will be subject to pretrial release. You are ordered not to engage in any criminal activity, not to use or possess any illegal drugs. You will be subject to random urinalysis screening at your own expense. Thank you.
Never.
Demario Hardin.
Mr. Hardin, you are charged with manufacture of cocaine, possession of cocaine with intent to sell, possess or use of drug paraphernalia, drugs, looks like with controlled substance without a prescription, possession of morphine, possession of cocaine, possession of fentanyl, and possession of fentanyl with intent to sell. Do you have an attorney?
No, ma'am.
Would you like one?
Yes.
Okay, I'll provisionally appoint the office of the public defender. And give me a moment while I review the charges.
Last 500. Yeah. Use of this out.
Counsel, do you want to be heard?
Yes, Your Honor. In regards to the manufacture of cocaine, I didn't see anything that really seemed to indicate that there was actual manufacturing of that or the possession of fentanyl with the intent to sell.
State, do you have a response?
Regarding the intent to sell, I would respectfully direct the court's attention to the portion of the affidavit narrative that speaks to numerous items found within the room that are associated with the cutting, the packaging, and the distribution of drugs, the measuring devices, the weighing devices, and the other items that were listed in that portion of the affidavit. With regard to the manufacturer, I can see, I don't see anything directly related to the manufacturing of the cocaine itself, only the possession with intent to sell it.
And Your Honor, just to address the intent to sell, a lot of what he listed are items that somebody would use for personal use as well, and not with the intent to sell.
I'll talk about it.
Based after a review of the affidavit in this case, I am going to find that there is probable cause for the charges of possession of cocaine with intent to sell, possession or use of drug paraphernalia, possession of controlled substance without a prescription, possession of morphine, possession of cocaine, possession of fentanyl, and possession of fentanyl with intent to sell. I do find probable cause is lacking on the manufacturer charge, so you'll be released on your own recognizance on that charge. In terms of the other charges, on the possession of cocaine with intent to sell, I'll impose a $20,000 bond. On the possession or use of drug paraphernalia, that will be $1,000 bond. On the possession of a controlled substance without a prescription, that will be a $10,000 bond. Possession of morphine, that will be $10,000 bond. Possession of cocaine, $10,000 bond. Possession of fentanyl, $10,000 bond. And possession of fentanyl with intent to sell, a $20,000 bond. If you are able to bond out, you will be subject to pretrial release. It will include the following conditions. You are not to engage in any criminal activity. You are not to use or possess any illegal drugs. You will be subject to random testing at your own expense. You are not to use, possess, or carry any firearms, guns, weapons, or ammunition. Thank you.
Miguel Hernandez.
Mr. Hernandez, you're charged with domestic violence, battery, touch, or strike. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, please.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment. We have a victim contact form. All right, next. Mr. Hernandez, having reviewed the affidavit in this case, I do find probable cause for the charge of domestic battery, touch or strike. I'm going to impose a $5,000 bond. If you are able to bond out, you will be subject to pretrial release. And this will include not possessing or carrying or using any firearms, guns, weapons, ammunition, or knives. You are to have no contact with the victim directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim, victim's home, vehicles, place of employment, and/or school at all times. You are to stay 500 feet away from the event location. I understand that this is your residence as well as the victim's. Is that correct? I think you're muted, Central.
Yes, and we share a child together. So.
Okay. You will be allowed to return to the residence within 48 hours after you're released from custody, accompanied by a law enforcement officer to retrieve your personal belongings.
Okay. Thank you, Your Honor.
All right, thank you.
Jarvis Johnson. Hernandez, report.
Mr. Johnson, you're charged with possessing or using a narcotic paraphernalia as well as possession of methamphetamine. Do you have an attorney?
No, ma'am.
Do you like one?
Yes, ma'am.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the charges. All right, can I see this history, please? Thank you. All right, Mr. Johnson, having reviewed the affidavit in this case, I do find probable cause for the possession and use of narcotic paraphernalia, as well as the charge of possession of methamphetamine. I will impose $1,000 bond on the possession or use of narcotic paraphernalia charge and a $10,000 bond on the possession of methamphetamine charge. Should you bond out, you will be subject to pretrial release. The conditions of those release are you will not engage in any criminal activity, you will not use or possess any illegal drugs. You will be subject to random urinalysis screening at your own expense. Thank you.
When's my next court date?
September 8th at 8:15.
Johnson. Garfield Kelly.
Mr. Kelly, you're charged with cannabis possession not more than 20 grams and possession or use of narcotics paraphernalia. Do you have an attorney?
No, ma'am.
All right, would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment, please. I'm seeing there's an open case, 26 CF 3584. He's on diversion for that.
Yes, ma'am, but in that case, my research at least indicated that the bond was not released on that case. Typically, the bond would be released if the case goes into diversion. I was never able to determine why that happens sometimes. But my reading of the procedural history in this case was that he is still on bond. That bond was posted on April 15, 2026. State's position is it does qualify for a Parker revocation.
Counsel,
What does that mean?
just one moment, sir.
I'm trying to look at that information.
We're looking something up, so just hold on one moment, please.
It was violated out of diversion. But again, I did not see where the bond was released in any way. And I may have missed it, but I looked closely.
Yeah, sure, I would say there are enough questions in this, that we should look into it, before we make any decision in regards to, revoking the pretrial. We could just have a motion at another time.
State was it, Mr. Parker. Thank you.
All right, based on what I have in the record in front of me, as well as the affidavits, I do find probable cause on these new charges of possession of cannabis, not more than 20 grams, as well as possession or use of narcotics paraphernalia. I will impose a $1,000 bond on each of those charges. Were you to bond out on those charges, you would be subject to pretrial release with the conditions that you're not to engage in any criminal activity, not to use or possess any illegal drugs, and that you would be subject to random urinalysis screening at your own expense. However, given the information that you are on pretrial diversion and nothing indicating that you've been released from that, I will revoke any bond or pretrial diversion conditions that you have there pursuant to Parker v. State. So you'll be held on no bond.
What the fuck?
So when is my next court date?
August 28th at 8:30. August 28th at 8:30, sir.
Bro, that shit is fucking ridiculous. Bro.
Sir.
Oh, well, fucking shit.
Sir.
Need him back?
Yes, please.
Step back in here, sir.
Step back up here.
What happened? I thought she told me to leave.
Step on.
I'm sorry. I apologize. I thought you told me to leave.
All right. I understand that you're frustrated, sir, by the circumstances, but this is a court and you are to show respect. Do you understand
Yeah,
that?
yes, ma'am. Of course. Yes, ma'am. Of course.
All right. Thank you.
Yes, ma'am.
Timothy Lehman.
Lamond.
Lamont.
Okay. All right, Mr. Lamond, in this case, you are charged with DUI with a blood alcohol
Yeah.
content of 0.15 or higher, as well as DUI with property damage or personal injury. Do you have an attorney?
No, I don't.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. Can you bring that back up to me, please? That, I am showing that we do have 2 open cases on him. The first one being 26 MM 5469, as well as 26 CT 3519. And that was a notice to appear on that second one.
With regard to the MM case, Judge, I'm showing that as a resist officer without violence and trespassing with a pretrial release order issued July 7, 2026, bond posted July 14, 2026. My analysis is that it is Parker eligible. State would so move upon a finding of public cause in the instant case. Thank you.
Did you want to be heard, counsel?
I'm just trying to, can I see the case?
I'll have you guys look over that while I look over the affidavit.
Yes.
All right.
Yes. Oh, they didn't forge it easy.
No.
They go to Deb and say it right.
She may have, and I didn't get it. I don't know.
Yes, ma'am. Yeah, I approached it.
Yes.
Okay. I'm not playing games.
That was a notice to appear, so it's not bonded. 30 days. Yes, ma'am.
Do you have anything further after conferring? Anything?
Nothing further from the state.
Nothing further, Your Honor.
Mr. Lamond, after reviewing the affidavit, I do find that there's probable cause for the charge of DUI with alcohol content of 0.15 or higher, as well as DUI property damage or personal injury. On the charge of DUI with blood alcohol content of 0.15 or higher, I am going to impose a $1,000 bond, and on the DUI property damage personal injury, that will also be a $1,000 bond. However, because you are on pretrial release from an earlier case, that release will be revoked and you will be held on no bond. Did I wait for him? Yes. Okay. I did not. If you were to bond out, sir, let me just follow back up with you on these new charges. You would be subject to pretrial release, and on those, you would be subject to not engaging in any criminal activity, not using or possessing or consuming alcohol at any bar or lounge, and random testing at your own expense.
Do you want your analysis?
Yes, your analysis, please. All right. Thank you, Mr. Lamond.
Thank you, Your Honor.
Daniel Maureen Guzman.
Does he not have Lopez?
I showed that.
Lopez Bonding.
Okay, Lopez bonded. All right, thank you. All right. Mr. Guzman, you are charged with petty theft, first degree, $100 or more, less than $750, as well as battery, touch, or strike, and resisting or obstructing an officer without violence. This is a result of a capias. He's already being held no bond. All right. All right. I do find probable cause on those charges, and you'll be held no bond. Was he appointed? Should I appoint a public defender for him? Okay. Do we have your private attorney on the line, sir?
I'm not sure.
Ms. Peraza? All right. It doesn't appear that she's here. Did you want to, I know I just found probable cause, but did you want to roll this to tomorrow so that you have a chance to contact her and have her appear with you at first appearance, or are you fine to go ahead with today?
I'm fine with today.
All right. So you're being held with no bond. Thank you.
When's my next court date?
September 3rd at 8:30.
Garrett Mills.
Mr. Mills, you are charged with violation of probation for DUI. I did look at this previously. I do find probable cause based on that violation of probation affidavit. Do you have an attorney?
No.
Would you like one?
Yes.
I'll provisionally appoint the public defender on this case. Based on the finding of probable cause, I am going to hold you no bond on that charge.
Okay.
Thank you.
Your Honor.
Justin Mills.
Mr. Mills, you're charged with domestic violence, battery, touch, or strike. Do you have an attorney?
Oh, no, ma'am.
Would you like one?
Yes.
All right, I'll provisionally appoint the office of the public defender. Just give me one moment. All right. Mr. Mills, having read the probable cause affidavit, I do find probable cause for the charge of domestic violence, battery, touch, or strike. I will impose a $2,000 bond on that charge. If you bond out, you'll be subject to pretrial release. And your condition for that is you are not to use, possess, carry any firearms, guns, weapons, ammunition, or knives. You are also prohibited from having any intentional contact with the victim, directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay 500 feet away from the victim's home, vehicles, place of employment, and school at all times. You're to stay 500 feet away from the event location. From my review of the record, it looks like that you and the victim both reside at this house. Is that correct?
It's my house. I'm on the lease and he's not. He just moved in.
State, do you have any input on this, since he's saying that the house belongs to him?
With all due respect to the accused, if the named victim has not been charged with a crime, that individual is not within the authority of the court directly. Only this individual is within the authority of the court. So if the court's intention is to keep them apart, the order of no contact has to go to this individual, and the order to stay away from the victim's home has to be placed upon this individual's shoulders. Thank you.
You could, Your Honor, order no violent contact, if you wish.
I mean, he's supposed to be bonding me out anyway, so I don't.
Don't talk about the substance of your case.
Regarding contact, typically there is an attempt to communicate with the victim. Again, I'm not directly involved in that process. If the victim has not affirmatively stated that the victim is seeking contact, I'll impose that at this time until more information can be presented to the appropriate court.
Okay. All right. All right, sir, I'm going to leave the previously imposed conditions. So you are not to have any contact with the victim. And you may return to the residence within 48 hours with law enforcement to retrieve your personal belongings. But at this time, you are not to stay at that residence.
Yes, ma'am.
All right, thank you.
I go home for somebody who's not even on the lease. That don't make sense. What's the other?
Looking for more?
Mr. Moore, you're charged with resisting an officer without violence, possession of drug paraphernalia, possession of methamphetamine, and possession of cannabis resin. Do you have an attorney? Do you have an attorney?
No.
Would you like one?
Yes.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review. All right, after reviewing the probable cause affidavit, I do find probable cause on the resisting an officer without violence charge, possession of drug paraphernalia charge, possession of methamphetamine charge, and possession of cannabis resin charge. I will impose bonds in the following amounts: $1,000 on the resisting charge, $1,000 on the possession of drug paraphernalia charge, $5,000 on the possession of methamphetamine charge, and $5,000 on the possession of cannabis resin charge. If you are able to bond out, you will be subject to pretrial release. You will not engage in any criminal activity. You will not use or possess any illegal drugs. You will be subject to random urinalysis screening at your own expense.
Ma'am, the officer have violated my rights.
Please do not speak about the substance of your case. Step aside, please.
Mason North.
Mr. Noss, you are charged with violation of probation for petty theft, first degree. I have previously reviewed this. Do you have an attorney?
No, I don't.
Would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. As I said, I previously reviewed this affidavit. Based on the affidavit, I did find there was probable cause, and you will be held no bond on this charge.
Yes, ma'am.
Thank you.
Jose Ojeda Morales.
Typically, the defense has to waive reading.
Yes, and let's ask if he wants an attorney.
Okay. Mr. Ojeda Morales, do you have an attorney?
No, ma'am.
Would you like an attorney?
Yes, ma'am.
Okay, I'll provisionally appoint the office of the public defenders, and she has waived the reading of the charges in this case. So just give me one moment while I review everything, okay?
Okay.
You know what they are?
Sharon. Which one is that? Oh, okay. All right. All right, state.
Your Honor, this is a no bond warrant on each of the two counts. Also, each of the two counts, because of their level, does not qualify for a bond. State is requesting he be held no bond. Thank you.
And Your Honor, we would ask for a bond in regards to these cases. Let's see, lives in Polk County and has ties to this area. We would just ask for one to be given to him in regards to this case.
Records indicate that he is out of county since 2014.
All right, based on the reading of the affidavit in this case, I do find probable cause for both of those charges, and you will be held no bond, sir. Thank you.
Question, Your Honor. When will be the next court date?
Next court date is September 8th at 8:15. September 8th at 8:15.
Thank you.
Thank you.
Matthew Pearson.
Did we already do Horace Hernandez? Did we get that one? Mr. Pearson, you're charged with possession of cannabis, not more than 20 grams, possession of drug paraphernalia, and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. Just give me one moment. Oh, he has an open case. I do see he has an open case, 26 CT 3060.
Yes, ma'am. And I showed that that went first appearance hearing on April 19th, 2026. And bond was posted on April 21st, 2026. Upon a finding of probable cause, the state will be requesting a Parker hold and the revocation of that bond. Thank you.
ask for there to not be a Parker hold. It looks in this particular case, that one, he was compliant with law enforcement, but also too, some of this evidence is based on burn and smell cannabis, which shouldn't be a reason to search. That's for a future motion to suppress, but I think you can take that under consideration this time when you're looking at a bond or whether to hold it.
All right, having reviewed the affidavit in this case, I do find probable cause for all three of the charges. That would be possession of cannabis, not more than 20 grams, possession of drug paraphernalia, and possession of methamphetamine. What was that? Okay, I'm sorry. I will impose a $1,000 bond on the cannabis possession charge as well as the possession of drug paraphernalia. I'll impose a $5,000 bond on the possession of methamphetamine. Were you to bond out on those charges, there would be conditions of pretrial release. That would include not to engage in any criminal activity, not to use or possess any illegal drugs, and also be subject to random urinalysis screening at your own expense. However, being that you were out on bond on another case, I will go ahead and revoke that bond and hold you no bond pursuant to Parker v. State. Thank you, sir.
When's my next court date?
That'll be September 8th at 8:15.
September 8th at 8:15.
Matthew Porter.
Mr. Porter, you are charged with possession of drug paraphernalia and possession of methamphetamine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, please.
I'll provisionally appoint the office of the public defender. Just give me one moment, sir. All right, State, I would just ask for your position on the drug paraphernalia charge.
Yes, ma'am. May I have just a moment? I can make argument with regard to use of a license and its utility processing drugs, but I believe that would require an inference. It's not explicitly stated in the affidavit. Based on the face of the affidavit, I will not request 24 hours to perfect the paraphernalia, but I would argue that there is PC for the possession of that. Thank you.
In regards to the possession of meth, Your Honor, it looks like there was something white on the license, the presumptive test. A lot of things could test presumptively for that. The presumptive test is just saying which classifications a lab should look at in which to test the drugs, because we have to have them tested. And I don't see anything that there's anything left over to test.
Any response? Say.
With respect, the purpose of the presumptive test is to establish which is the purpose of these hearings today. To find otherwise, again, respectfully, would mean that no drug arrest could be made until FDA had returned the lab result, perhaps once a week.
I don't take that so broadly, because again, it's looked up that this could be used up. This is little pieces of white things on the license. It's commonly used. And I put it in my wallet. And I put it by dollar bills. And I think we know that there are a lot of things that are on dollar bills, even they test positive for cannabis or for cocaine at times, because people use them for a variety of things. But I just don't think there's enough to really say that they could actually proceed with the prosecution past this point.
There is case law regarding dollar bills, but I believe that body of case law is based on the fact that dollar bills are widely exchanged among individuals. The item in this case belongs to three physical persons. There is no minimum amount of methamphetamine that one can possess legally.
All right, Mr. Porter, I have reviewed the affidavits, and after listening to both the state and the public defender today, I am going to find that there is a lack of probable cause on the possession of drug paraphernalia, so you will be released on your own recognizance on that charge. I do find that there is probable cause for the possession of methamphetamine charge. Your bond on that will be set at $5,000. If you are to bond out on that charge, you will be subject to pretrial release. You're not to engage in any criminal activity. You're not to use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you, sir.
Thank you.
Sure. Pearson, 4. Alexander Preston.
All right, Mr. Preston, you are here on failure to maintain vehicle liability insurance, possession of drug paraphernalia, possession of a controlled substance without a prescription, possession of cocaine, possession of fentanyl, possession of cannabis resin, failure of a registered owner of vehicle to notify the DHSMV of a change of address, and operating while driver's license is suspended, canceled, or revoked, second conviction or subsequent. Do you have an attorney?
No.
Would you like one?
Yes.
Okay, I will provisionally appoint the office of the public defender. Just give me one moment to go over the documents. Please stop speaking. All right, Mr. Preston, having reviewed the documents in this case, I do find probable cause for failure to maintain a vehicle liability insurance, possession of drug paraphernalia, possession of a controlled substance without a prescription, possession of cocaine, possession of fentanyl, possession of cannabis resin, failure of a registered owner of vehicle to notify the DHSMV of a change of address, and operating a vehicle while driver's license is suspended, canceled, or revoked, your second conviction or subsequent. offense. I will impose a bond of $500 on the failure to maintain vehicle liability insurance, $1,000 on the possession of drug paraphernalia, $5,000 on the possession of a controlled substance without a prescription, $5,000 on the possession of cocaine, $10,000 on the possession of fentanyl, $5,000 on the possession of cannabis resin, $1,000 on the failure of registered owner to notify the DHSMV of a change of address, and $2,000 on operating while driver's license suspended, canceled, or revoked, second conviction. Should you bond out on those charges, you will be subject to pretrial release. You are not to engage in any criminal activity. You are not to use or possess any illegal drugs. You are not to drive without a valid driver's license or permit, and you will be subject to random urinalysis testing at your own expense. Thank you, sir. Mr. Pruitt? You're muted. Central?
Yes, ma'am.
All right. Mr. Pruitt, you are charged with operating while your driver's license is suspended, canceled, or revoked. Third conviction. Do you have an attorney?
No, ma'am, I don't.
Would you like one?
Sure, yes, ma'am.
All right. I'll provisionally appoint the Office of the Public Defender. Just give me one moment. All right, Mr. Pruitt, having reviewed the probable cause affidavit in this case, I do find probable cause for the charge of operating a vehicle while driver's license suspended, canceled, or revoked. Third conviction. I will impose a $10,000 bond in this case. If you bond out, you will be subject to pretrial release with the condition that you are not to engage in any criminal activity and you are not to drive without a valid driver's license or permit. Thank you.
Thank you.
Over here, Mr. Pruitt. Jordan Ryder.
Mr. Ryder, I have you here first on a violation of probation, possession of drug paraphernalia, and then a second violation of probation. This is a felony possession of cannabis over 20 grams. Do you have an attorney?
No, ma'am. What's the violation for?
Possession of drug paraphernalia and a felony possession of cannabis.
That's
Would you like-
why. That's why. I was-
Don't say anything about the substance of your case. Do you have an attorney?
No, ma'am.
All right. Would you like one?
Yes, ma'am.
All right. I'll provisionally appoint the Office of the Public Defender. I've already previously reviewed the affidavits in this case, and I do find probable cause for both of those. And because they are violations of probation, you will be held no bond.
When's my next court date?
September 1st at 8:30. Thank you.
Ryder. Oh. And then Rivera, Robert Rivera. What the?
Mr. Rivera, you're here on a charge of loitering or prowling, tampering with physical evidence, possession of drug paraphernalia, a smoking device, and possession of cocaine. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment while I review the charges. right. Mr. Rivera, after I've reviewed the affidavit in this case, I do find probable cause for the charges of loitering and prowling, tampering with physical evidence, possession of drug paraphernalia, and possession of cocaine. I will impose $500 bond on the loitering or prowling, $5,000 bond on the tampering with physical evidence, $1,000 bond on the possession of drug paraphernalia, and $5,000 bond on the possession of cocaine charges. If you bond out, you will be subject to pretrial release. You are not to engage in any criminal activity. You are not to use or possess any illegal drugs. You will be subject to random urinalysis screening at your own expense. Thank you, sir.
Ma'am, could I ask my next court date is, please?
September 8th, 8:15.
September 8th at 8:15.
All right, thank you, ma'am.
Thank you.
Dion Robbins.
Mr. Robbins, you are here on a charge of violation of probation, resisting a law enforcement officer with no violence. Do you have an attorney?
Did I resist a law enforcement officer?
Sir, please don't talk about the substance of your case. Do you have an attorney?
I had one on my case that gave me the plea bargain of probation.
Okay, but do you have an attorney that is going to represent you on this case?
I hope it's the same appointed attorney, Nicholas, I forget his last name. Thank you, for requesting that. I had no.
Okay. All right, sir, because you don't have the attorney that you had last time with you here, I'm going to provisionally appoint the public defender on this case for you. Okay, I have previously reviewed the violation of probation affidavit in this case, and I do find that there is probable cause for the violation, so you will be held no bond on this charge, sir.
Your Honor, it wasn't a criminal, there was no charge.
Sir, please do not speak about the substance of your case. The public defender's been provisionally appointed, so if you have any questions, you can contact them.
It's just
We're gonna have somebody
surprising.
out to see you, sir. It's the best that you don't talk right now, and we'll talk and prepare for defense and go from there, okay?
And when would the court date be?
September 1st at 8:30, sir. Thank you.
Thank you.
Good afternoon.
Robert Fisher Robert.
Robert's the last name.
Oh, Roberts is the last name.
Okay. Mr. Robert, you are charged with cannabis possession, not more than 20 grams, and possession of drug paraphernalia, a container. Do you have an attorney?
No, ma'am.
Would you like an attorney?
Yes, ma'am.
All right, I'll provisionally appoint the Office of the Public Defender. Just give me one moment, please.
I'm Robert. Yes, sir.
All right, sir, having reviewed the probable cause affidavit, I do find probable cause for both of those charges. I will impose bonds in the amount of $1,000 on each of those charges. If you are to bond out, you will be subject to pretrial release. You are not to engage in any criminal activity. You are not to use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you, sir.
Yes, ma'am. Thank you.
Robert Salas.
All right, Mr. Salas, you're charged with battery, touch, or strike, and then domestic violence battery, touch, or strike. Do you have an attorney?
No, ma'am.
Would you like one?
Sure.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment, sir.
It's currently out on pretrial.
Okay, can you bring that back up for me? All right, I'm showing that he has an open case, 26 CF 6167.
Thanks, remember, I wasn't able to locate that earlier. I may take notes of that.
Do we have that victim statement in this one?
6167. Oh.
All right, State, do you have any comment on the open charge?
Yes, ma'am. I'm showing in that case number, the CF 266167, with the first appearance on June 24th, 2026. A bond was posted on June 26th, 2026, and the charges on the affidavit for the arrest were possession of meth and paraphernalia. State requests revocation of that bond and we help her search warrant.
It looks like we don't represent him, looks like regional counsel did, represents him. So before revoking that, I would ask that his counsel be able to, if they would like to be able to talk about that matter. Perhaps the state could file a motion and set a court hearing so that they can be heard.
Respectfully, Parker does not entitle the defense to a hearing. It's actually a sua sponte authority of the court. So certainly the court can set it for a hearing. The court can also hold a no bond even without telling you. Thank you.
Yes, it is a sua sponte or a motion that the court can do. Thank you.
All right, Mr. Salas, after reviewing the affidavit in this case, I do find probable cause for both of these charges. I am going to impose a $5,000 bond on each of them. Were you to bond out on these charges, you would be subject to pretrial release. As part of the conditions of that pretrial release, you would be ordered not to engage in any criminal activity. You would also be ordered not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You would be prohibited from having any intentional contact with the victims directly or indirectly, in person, in writing, by telephone, pager, fax, texting, email, social media, or through third persons, except for scheduled court proceedings. You must stay away 500 feet from the house, the victim, their vehicles, places of employment, and schools at all times, and you would be required to stay 500 feet away from the event location. However, because you are on bond on the other case, that will be revoked and you'll be held no bond pursuant to Parker v. State.
When am I on next court date?
August 28th at 8:30. August 28th at 8:30. Thank you, sir.
Mario Santiago.
Mr. Santiago, you are charged with cannabis possession not more than 20 grams and possession of drug paraphernalia, a container. Do you have an attorney?
No.
Would you like one?
Yes.
I'll provisionally appoint the Office of the Public Defender. Give me one moment. This is the other. I just want to make sure we're on the right case. Okay. All right, Mr. Santiago, having read the probable cause affidavit in this case, I do find probable cause for both counts, the cannabis possession not more than 20 grams and the possession of drug paraphernalia. I will impose a $1,000 bond on each of those charges. If you bond out, you will be subject to pretrial release. The conditions of that pretrial release: you are not to engage in any criminal activity, do not use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you, sir.
Thank you.
Oh, good money.
Is this Mr. Sellers?
Yes, it is. Randy Sellers.
Yes, ma'am.
Mr. Sellers, you are here on trespass, failing to leave property on the order of an owner. Do you have an attorney?
No, ma'am.
Would you like an attorney?
Yes, ma'am.
Okay, I will provisionally appoint the Office of the Public Defender. Just give me one moment, sir. All right, Mr. Sellers, having read the affidavit in this case, I do find probable cause on the charge of trespass, failing to leave the property on the order of the owner. I will impose a $1,000 straight bond on this. Thank you, Mr. Sellers.
All right, thank you.
Tyler Simpson,
Mr. Simpson, you are charged with possession of cannabis, resisting without violence, and possession of drug paraphernalia. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am. Yes, Your Honor.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment, please. All right. Mr. Simpson, I have read the affidavit in this case, and I do find probable cause on the charge of possession of cannabis, resisting without violence, and possession of drug paraphernalia. I will impose a $1,000 bond on the possession of cannabis, $1,000 bond on the resisting without violence, and $1,000 bond on the possession of drug paraphernalia. If you do bond out on these charges, you will be subject to pretrial release. This will require you not to engage in any criminal activity, not to use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense.
Yes, Your Honor.
Thank you.
Thank you.
Oh, I'm sorry.
I was gonna ask her for my next
All
court
right,
date.
I was just making sure that we appointed the public defender for you, but we did.
Oh, sorry. Sorry.
All right, thank you.
I was gonna ask you when my next court date is.
August 28th at 8:30.
Oh, thank you.
All right,
I'm
thank
good.
you.
Calvin Stokes,
Mr. Stokes, you are charged with
Good.
resisting. You're charged with resisting an officer without violence. Do you have an
Yes, ma'am.
attorney?
No, ma'am.
Would you like one?
Yes, ma'am, Your Honor.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment, please. All right, Mr. Stokes, having read the probable cause affidavit in this case, I do find probable cause for the charge of resisting an officer without violence.
Yes, ma'am.
I will impose a $2,500 bond in this case. If you do bond out, you will be subject to pretrial release. You are not to engage in any criminal activity, use or possess any illegal drugs, and you will be subject to random urinalysis screening. All right, thank you, sir.
Yes, ma'am. Thank you.
Matthew Tribby,
Okay. All right, Mr. Tribby, you are charged with possession of drug paraphernalia and possession of cannabis resin. Do
Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
All right, I'll provisionally appoint the office of the public defender. Just give me one moment, please. Mr. Tribby, based on my reading of the affidavit, I do find probable cause for both the charge of possession of drug paraphernalia and possession of cannabis resin. On the charge of possession of drug paraphernalia, I will impose a $1,000 bond. On the possession of cannabis resin charge, I will impose a $5,000 bond. If you are to bond out, you'll be subject to pretrial release with the following conditions. You're not to engage in any criminal activity, use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you, sir. I think you're muted, Central.
Scott Walton.
Mr. Walton, you're charged with possession of drug paraphernalia and possession of methamphetamine. Do you have an attorney?
No.
Would you like one?
Yes, please.
All right, I'll provisionally appoint the office of the public defender. Just give me one moment, please.
Okay.
All right, Mr. Walton, having read the affidavit, I do find probable cause in the charge of possession of drug paraphernalia and possession of methamphetamine. I will impose a $1,000 bond on the possession of drug paraphernalia and a $5,000 bond on the possession of methamphetamine. If you do bond out, you'll be subject to pretrial release. You are not to engage in any criminal activity. You are not to use or possess any illegal drugs, and you will be subject to random urinalysis screening at your own expense. Thank you, sir.
Thank you.
John Whitaker.
Mr. Whitaker, you're charged with resisting without violence. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I will provisionally appoint the office of the public defender. Just give me one moment, please. Tell me what confirmation for, what charges in this one.
He was on probation.
26, okay, 1556.
I did want to note that he does have a case 26 MM 1556 that he is currently on probation for.
You said
1556, yes.
Just for trespass.
I'll just make my challenge to the probable cause.
I guess it was you.
Yeah. In regards to Mr. Whitaker, looking at the affidavit, it seems he was trying to walk away from law enforcement. They just wanted to see if he possibly had a warrant. They didn't check to see if there was any warrant. So I think he did at that point have the right to just walk away from them. They didn't have a right to detain him for anything because they didn't know he had a warrant and so forth like that. So I think he had the right to walk away. But I did do a case Ferguson versus State, which basically I had a client that was trying to avoid law enforcement when they came. That's what the officer said. He was trying to be in the doorway area where the officer thought he was loitering and prowling. And the court did mention that if somebody's on probation, you might want to avoid law enforcement and not coming into contact with law enforcement. And one of the provisions of probation is that you try not to come in contact with law enforcement. So I think it's perfectly in his right to walk away at that time.
State.
Well, starting from the end, it's there from the affidavit that officers asked him to stop and he did not. So I think that it is not disputed that he did not follow their order regarding whether it was lawful. The affidavit indicates that officers were there to serve a warrant. It was not on Mr. Whitaker, but it was on a person who was suspected of vehicle location. While officers were trying to serve that warrant, they received information, it appears, from numerous people saying that Mr. Whitaker had a warrant. So as officers tried to investigate that, he refused to obey their commands to stop while they did that investigation. I would argue they had a reasonable suspicion to stop him to follow through on that. And so I would argue that at least for purposes of probable cause, there is sufficient evidence to find that. And also note that it appears there is a violation of probation affidavit for Mr. Whitaker in MM 26-1556. Now I see that in stack. Stack updates, when it updates, I'm not a computer person, so I don't know specifically how that timing works. So I do not know, but the affidavit reads that law enforcement did not locate a warrant for Mr. Whitaker. I do not show a warrant for Mr. Whitaker, but with there being an affidavit of violation of probation that was at least put in stack on the 7th, today, I would argue that those things taken together, officers had sufficient legal grounds to attempt to stop him, and in refusing to do so, that their order was lawful under those conditions. Thank you.
You're saying the affidavit of violation went in today?
It went into stack today here, but if I may pull up the affidavit. It was issued by Officer Gonzalez on the 5th, August 5th, and the clerk, it was also a 5 on the 5th by a notary.
Do you have any position on whether, if I did find probable cause on this, that there would be any Parker issue here on this?
I do not believe there would be a Parker issue. I would be requesting an instantial warrant. I believe I can request an instantial warrant based on the violation of probation affidavit, but that would be atypical, and I want to be straightforward about that. I think this court has the authority to issue a warrant based on that affidavit, but it would be unusual to do that at first appearance. I do want to be clear about that. That being said, it is not a Parker issue. It would be an instantial warrant on the violation of probation. And the reason for the violation is not the new law violation, not the resisting without. The allegation of the affidavit is failing to report on at least three occasions, June, July, August of 2026.
All right, Mr. Whitaker, having read the affidavit, and based on the contents therein, I do find sufficient probable cause for this charge of resisting without violence. I am going to impose a $1,000 straight bond.
Or having found probable cause for a new charge, I would request an instantial warrant based on that finding in MM 261556.
Do you have a position on that?
Yes. Yes, Your Honor, we would ask if you have found probable cause and so forth. In regards to that we be appointed to both cases if you're going to do an instantial warrant to make sure that we're appointed to both.
I will, subject to the state's request, I will issue an instantial warrant on that violation of probation charge, and I will provisionally appoint the public defender on that charge as well, Mr. Whitaker. Thank you.
What's my court date?
His next court date will be August 28th at 8:30.
August 28th at 8:30.
William Young.
All right, Mr. Young, you are charged with resisting without violence, trafficking in amphetamines, possession or use of narcotic paraphernalia, no motor vehicle registration, driving while license suspended or revoked, second or more prior conviction, felony possession of cannabis, and tampering with physical evidence. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. Just give me one moment, please. I do see that he is out on bond in another case, 25 CF 7936.
Yes, ma'am. I'll also ask to be heard on the case on the docket.
Okay, just one moment.
Yes.
Oh, no.
Can you go back to the update, please? Mr. Cavius. It's okay.
Your Honor, I have a question.
Just please.
Not about the case.
Don't speak right now, sir.
Your Honor, I was just wanting to know how I got charged with resisting. I was in it.
Sir, please do not talk about the substance. Just give
I'm
me
not
another
talking
moment.
about it. I was hospitalized.
Please do not ask any questions, okay? The Office of the Public Defender has been appointed to represent you, and if you have questions, you can speak to them, okay? But I'm just reviewing another document. So please just
Okay.
give me a moment to finish that.
Okay, I was just wondering, I was hospitalized. I didn't.
Could you please stop talking? We're trying to review the information to help you out. I
Yes,
can't do
ma'am.
that if you keep talking. I have to manage you Okay, so
Yes, ma'am.
just be quiet, please.
Yes, ma'am.
Oh, yeah. The night, like the dorm night, yeah, I know, because I read the job today and said it goes to my work.
For warrant, but I don't see the one charge. I'm just trying to find it. The driving licenses. This was a directive provision. All right, I just wanted to write it down. All right, State, would you like to be heard?
Sure. In this case, the state has filed a charging information. That information includes count 1, trafficking in amphetamine, 14 grams or more. Presuming a finding of probable cause, the state is filing a motion for pretrial detention. Trafficking in any drug qualifies for pretrial detention under 907041 5C3. I'm providing a hard copy of the motion to appointed counsel. May I approach?
Yes.
State would respectfully request the court review this motion for facial sufficiency. If so found, hold the accused no bond pending a hearing on this motion, which should be set next week on Thursday at 1 p.m. on the A2 docket. I would also ask to be heard regarding the bond case. Thank you.
All right, Counselor, I'll give you a chance to tell me anything that you want to tell me.
Did you want to speak first on the bond?
No, I'll table that to Mr. Keys. Thank you.
Yes, Your Honor. In regards to the case, there's a motion for pretrial detention that they have filed, and they are due a hearing. We ask in the meantime for bonds to be given to my client in regards to the cases, so that he can find out if he should like to.
All right. Based on a review of the documents that we have, including the information that has been filed, I do find probable cause on all of those charges: the resisting without violence, the trafficking in amphetamine, possession use of narcotic paraphernalia, no motor vehicle registration, driving while license suspended or revoked, 2+ prior convictions, felony possession of cannabis, and tampering with physical evidence. I will hold Mr. Young on no bond based on that motion for pretrial detention, which I do find facially sufficient. And State, I know you wanted to make an argument regarding the bond in the other case.
Yes, ma'am. With regard to CF 257936, the charges in that case were possession of more than 20 grams of cannabis, possession of paraphernalia, and possession of methamphetamine. My review of the procedural posture was that it went to first appearance on September 3rd, 2025. Bond was posted on November 7th, 2025. State is asking the court to revoke that bond and hold the accused no bond in that case upon the finding of probable cause in the case before the court today. Thank you.
Yes, Your Honor. Looks like Mitch Lardner is his attorney in that case, and I think he would like to be able to have that attorney address these issues.
Yes, because I was a victim. I was pushing a bike.
Sir, please do not talk about your case. Once
I'm
again.
not. I was pushing a bike down the road and I got hit by someone.
Sir, please stop talking, okay? The Office of the Public Defender has been provisionally appointed to represent you on these charges. So if you have any questions or any statements you'd
I
like
don't
to
have any
make about,
questions.
okay, but any statements that you would like to make, you need to make that to your public defender, okay?
I don't
And have that
understand why,
conversation with her.
why I wasn't charged at the scene with anything. Now I'm being charged 2 months later.
Sir,
we will come out and talk to you, okay? And
Okay.
Mr. Lardner will probably talk to you as well.
Okay,
All right, Mr. Young, based on the finding of probable cause in this case, I will revoke the bond in the other case, so you will be held no bond on that as well. Thank you.
Are you holding the accused no bond on all the counts until the motion for pretrial detention is heard, or are you setting bonds on the non-qualifying counts?
I will set bonds on the non-qualifying accounts. I'll just hold him on the pretrial for the trafficking account.
Yes, ma'am.
I waive his appearance on the matter for, getting the bond out right now.
Okay, all right. Parents waived on those other charges. On the resisting charge, that will be $1,000 bond. On the narcotic paraphernalia charge, that will be also $1,000 bond. On the no motor vehicle registration, also $1,000 bond. On the driving while license suspended or revoked, 2+ prior convictions, that will be $5,000. Felony possession of cannabis, that will be $5,000. Tampering with physical evidence, that will be $5,000. Should he bond out, he would be subject to pretrial release. Do not engage in any criminal activity, do not use or possess illegal drugs, and random urinalysis screening at his own expense. And then also, based on the driving charge, no driving without a valid driver's license or permit.
Just let the record reflect that he did come back, so he was able to hear all of that.
Okay, yes, let the record so reflect. All right, thank you, sir.
Where he at, four? Yeah, 1 or 4. 4. 4. You going at the door?
This is the only thing I have left for you to sign.
That's all we have, Judge.
All right, thank you. Oh, wait. All right, hold on 1 second.
Robbie?
What was the last name? Cartree? Start with a C, I assume?
Yes.
I have that he was transferred.
Transferred. What about Johnson?
Yeah, Ronald Johnson.
Hospital.
Yep.
Thank you.
Hospital. What about Rivera Alicia?
Transferred.
And Starks.
I have not needed. I'm not sure what that means, but that's what I have written down on this. It says not needed.
What was the name?
Symphony Marie Starks.
Starks?
Symphony Marie Starks.
That's all we got to.
How do you say that, Jensen?
Symphony.
I have that, this defendant went to first appearance previously and wasn't added onto the docket in there.
Okay,
Okay.
all right.
May I inquire about the Patrice Brooks
Hospital.
Hospital? Okay, thank you.
Is there anyone else from either of you?
Not for me.
All right.
Thank you,
Stand in
very much.
recess and go off record.
In the cases for the ones that
We need to sign it.
Mr. Brooks and stuff at the hospital, for him, is he gonna be back tomorrow, or are we setting a date for him?
It's being brought back. Just wait for me 1 second, I just wanted to make sure I get this correct.
Okay.
This one was a WAJ for Pasco County.
Mhm.
I cannot remember if you addressed that he had a 50,013 bond.